My lord,
Lord,
may I seek my lord's leave, my lord, to mention one extreme urgent matter. My lord, leave to file and to, my lord, keep the matter, my lord, tomorrow or day after. As my lord, on 7th of January, I have received a letter from my lord, the Deputy Secretary to the Government of West Bengal under the Enemy Property Act, my lord, for evicting me with due force of police. On and 10 days time was given to me, and that is going to expire on, my lord, this Friday, 17th of this month. My lord, any day subject to your lordship's convenience, tomorrow or day after, my lord.
Enemy property.
Yes, your lordship. I have been there as an occupant, as a tenant, my lord. 2005 was the agreement. Prior to that, my father, grandfather used to be in that property.
Very well, serve notice upon all the parties.
My lord.
Day after tomorrow it will appear.
Deeply obliged, your
Lordship, yesterday before rising, I have mentioned item number 304. That matter, Lordship disposed of, and after disposing of, the CSC authority disconnected the connection.
Yes.
Lordship,
have for instructions, my lord.
Lordship,
Lord, I
Mr.
have
Ghosh is
received
here.
it right now. My lord, it's a very short instruction, my lord.
Tell it, don't give it to me.
My lord, what has happened, my lord?
Whatever may be happened. Yesterday, the matter was there in the list for quite some time.
My lord.
Yesterday, the moment the matter was taken up and an order was passed, you go and disconnect the supply.
No. This connection was done in the afternoon. Subsequently, the matter was heard. The fact is that, my lord, the due was pending since June, and my lord, the amount ultimately rose up to almost 80,000. Time and again, we have tried to contact the original consumer, my lord, but the letters have come back from the postal department, my lord, as not found.
That is
We have also tried to communicate the petitioner, my lord. She has received, but she has never responded.
Whatever.
Lordship, we have filed before
Mira,
the GRO in the month of August. It was pending, and all on a sudden they have gone.
responded. Immediately we have responded. and we
Is
have
your
sent
application pending before the GRO?
His Lordship directed the GRO to
My lord.
dispose
Consider.
it of, but they have
And
disconnected
time limit was fixed
8 weeks.
8 weeks. I'll reduce the time
My
limit
lord.
to
4
fortnight. Fortnight, you go and immediately disconnect, and then why 4 weeks? Fortnight's time, I'll make it.
Fortnight.
Item number?
Item number 304 of the monthly list.
আচ্ছা কেউ আছে অ্যাপলেট সাইডে কালকের আইটেম 4 টাইমটা 8 সপ্তাহ ছিল সেটা 2 সপ্তাহ হবে একটু বলে দেবেন
May I submit my report? Not required.
May our lordship kindly leave to
Mr. Patro, yes.
My lord,
Grateful.
I'm praying for upgradation of one matter from the monthly serial number.
But then I am not allowing upgradations. I have already taken up upgradations on the very first Monday of the month. So rest of the month, no further upgradations.
My lord, then may I try my luck in the next month? My lord?
Sure. Not luck. Anybody who comes, I more or less allow the prayer.
Very well, very well.
My lord, only one thing, my lord, I'm sorry. My lord, since we are not being able to contact the original consumer, my lord, kindly
Contact
ask
the learned. Please
the
do.
actual address.
All right, and you can get hold of the advocate and record of the petitioner. Send communications to him also.
May our
Item number 120.
May our lordship kindly leave to mention, my lord, this is an urgent motion, my lord. I need to leave, my lord. The petitioner is, my lord, then practicing advocate of, my lord, Chanchol, sub, my lord, the bar association of Chanchol, my lord, restricted him to practice, my lord, for not complying some directions issued by the, and my lord, disbarred from the bar.
Issued by
So,
them means issued
But
by
it's
whom?
bar association, and they have the restriction imposed from practicing therein, and try to hinder, make it
Will
hinder.
the petition be maintainable against the bar
No, my lord,
association?
I'm under the under section 6 of the advocate as well. I wrote to the authority, the
Yes.
bar council of state of West Bengal. There is a section, section
Bar
6.
council has not taken any steps.
That I have wrote to them that the protection has to be given under section 6. But that has not been given to me. Your lordship can appreciate. He is an advocate, practicing advocate therein in the subdivisional court. He is debarring from entering into the premises on the grounds. This is very, because of last 6 months, this has been done. It started, he wrote to the authority also that they are not taking any steps. Kindly appreciate these things. He has everything.
Very well, day after tomorrow it will
My
appear.
lord,
Serve notice.
My lord.
Bar council must be a party.
Yes, my lord. The Bar
Sir.
Council of India and State Bar Council also the party.
What has India got to do over here?
According to hierarchy, there is the procedures, I have. That's why, not only.
My lord,
Let me have your lordship's kindly.
1 minute, yes.
My lord, with regard to item number 125 of today's list, my lord, there's an extreme urgency, my lord. My lord, the IOB, the Indian Overseas Bank, is going to declare me, my lord, as a willful defaulter, without hearing me, without giving opportunity of dealing with the documents, without delivering the documents, my lord. In earlier occasion, my lord, a
It's
similar,
all right. So what is to be done? Upgraded?
my lord, upgraded either tomorrow or day after tomorrow. My lord,
Then
20th, my
from
lord,
supplementary list, you want upgradation?
my lord, the urgency is this, my lord, that they are going to declare me as a willful defaulter on the 20th. Either tomorrow or day after tomorrow, as your lordship pleases, ma'am.
20th is still some way to go. Next Monday. You have to serve the bank.
No, service has been completed.
No, but then the matter is appearing as item 125. It will suddenly be upgraded. How will
My
the
lord,
other side get to know?
I shall immediately communicate it to them.
Let it come on Monday only. 20th, let it
My
come.
lord, 20th is the meeting.
Let
date.
the date be there. 20th, it will come as urgent motion. 125 of the daily list served notice.
Within first 10 matters, my lord. Otherwise,
10. There are urgent motions. We do not have 10 urgent motions at all.
lords.
Yes, please.
Kindly leave to mention item 124 of today's list. But
Hmm.
I would have prayed for upgradation, but I'm only praying for the matter to appear as to be mentioned. I need your lordship leave to correct the cause title to add a address so that I can effect service. On that day, with regard to upgradation, I'll make my prayer, but let it appear as to be mentioned. I need your lordship leave to effect service by just changing the address. Unless your lordship gives me that leave, I'll not be able to. Unless your lordship gives me the leave right now, my lord, I'll just do it.
Who are the parties to you?
RDSO is a party. We've served them on a particular address which has come back saying that this is insufficient particulars. So we'll have to serve them on an address which is a fairly place, which is not here.
It may not be here, but then you serve at the right address.
Lordship, then just give me the leave to amend it right now, correct the cause title by hand mat, because on record we'll do it and serve it.
Only this much?
Only this much.
All
When
right.
it comes as to be mentioned, I renew my prayer.
No to be mentioned, because your prayer for to be mentioned is allowed here and now. Why is it required to come as to
That's
be
not
mentioned?
required for to be mentioned. Then I'll serve and come back and mention one.
Very well.
Lordship, may I be mentioned?
Item number 124, please record an order. Nirmal babu, একটা order লিখুন তো আজকের লিস্টের। Leave granted to the advocate on record of the petitioner to put in the proper address of the respondent number 1 in the cause title of the writ petition and effect service of the writ petition upon the said respondent.
Very great.
Lordship,
Yes.
may I be permitted for restoration application?
No.
Inclusion.
No.
For inclusion as motion.
No. No inclusions and no upgradations.
Of the same, because the
Why?
that it was wrongly filed under group 9 head, but it will be under group 1. So kindly
Group 1. Which item?
so it is not in the monthly, it is not even in the list. It is the case is in this court. It is not appearing before any court.
In this court. Give the number for release. Find it out for release.
My lordship's kind leave.
Mention one matter, my lord, the petitioner, this matter is appearing as item number 2237 of my lord's combined list, lordship, of this month. Lordship, in this case, my lord, the petitioner appeared in the written examination.
We want upgradation?
Lordship.
I am not permitting.
My lordship.
Yes.
Mention two identical matters for restoration.
No, sorry.
With my lordship's kind permission, my lord, item number 281 of your lordship's list, I'm praying for non-prosecution, my lord.
281 of the daily list?
Monthly list, my lord.
Monthly list. Non-prosecution, why?
Your lordship, I'm being led by my senior, my lordship.
Your senior may lead you, but what is the reason for non-prosecution? Get yourself ready and then mention.
On 14th August 23, the Honorable Justice.
You want upgradation?
No, my lord, for inclusion.
Inclusion, it mention on the day of when mentioning is taken for inclusion. Every day matters cannot be included. Yes.
My lord, on 14th August 23, Honorable Justice Secretary Saraf was pleased to direct the matter to be appeared 8 weeks hence.
Yes.
But it has not come.
From 8 weeks to 18 weeks, 28 weeks have passed.
Madam,
You have not mentioned. Now it will not be done.
Waiting for
Yes, call the list, please.
my lord, as per direction.
Lordship, may I be permitted to mention a matter?
No, list has been called. Yes, item 1.
Like to appeal for the petition.
Right.
It's an application for contempt on the last occasion. My learned senior friend have sought for time to submit.
This is a report, Lordship, the demolition work, because additional 2 floor was done, my lord. It's a huge, my lord, 8 Pagladanga. 8 Pagladanga, my lord, huge area. Lot of, my lord, stores, buildings are there.
And all unauthorized.
That I am not going to say, but
Why will you not say? You must
in
be having
respect of one,
instruction.
in respect to one building, my lord, the case was done.
All
We
right.
got instruction in respect of that building only. That's why it is, my lord, said that 8 portion Pagladanga. Kindly see, my lord, we have complied, my lord's order. Every, my lord, all the actions have been taken. So far as 2
My lord,
floors are
I have
concerned, kindly see, my
photograph.
lord, there are
Yesterday,
some. actually.
Yesterday you took photographs and it has not been demolished. Show me the photo.
My
now
lord,
few
pillars and a few part, a little part of the, my lord, entire building where an old lady is crying all the time and she is, my lord, calling all, my lord, neighbors and everything. Our people are going there and, my lord, facing some difficulties. But even then, lordship kindly sees, we have fixed also further demolition work to be done.
When?
My lord, on my lord, 20th January and 25th to 20th January to 25th of January, the program, last program, Sunday except Sunday to Saturday. Kindly see, my lord, the report, the third paragraph. So everything, and kindly see the, my lord, paragraph, the photographs. What huge work has been done. But even then, some problem is there we are facing, lordship. That is also, we have to comply with my lord's order. There is no, my lord, compromise. We cannot-
20th January and from 20th to 25th. Very well. I'll wait for some time also.
Lordship,
Please come.
lordship. And my lord, kindly be satisfied that because
A report
how
has
huge
been produced
task has been, my lord, completed.
by the learned advocate representing the contender, signed by 3 engineers of the
And my lord, one more thing.
building department of the Kolkata
Lordship, one
Municipal
second, lordship.
Corporation, Borough, VII.
Executive engineer personally also present, my lord, to just 45 to 35 our comments and how he is doing the work, lordship.
But there was no direction for his appearance.
No.
He has come here
We
to hand
requested
over this copy to you and he is over here. Let him remain.
No,
Lordship,
not that. Yesterday, my
it
lord,
appears
evening we had-
therefrom that certain demolition work has taken place and the next date fixed for demolition is from 20th January 2025 to 25th of January 2025, except Sundays and holidays. Stop paragraph. Learned advocate representing the petitioner submits that the demolition is yet to be made. Paragraph. Let the matter appear in the list on 17th of February 2025. Stop. An updated report shall be filed on the adjourned day, annexed with photographs. Stop. It will be open for the petitioner to produce photographs of the unauthorized structure on the adjourned date.
Grateful.
27th, lordship.
17th.
17th February. My lord.
If your lordship recollects, on the last occasion, this is relating to, my lord, that master circular for fraud classification and reporting. Our challenge is that no notice. No
My lord,
opportunity.
before my learned senior friend makes his submissions, my lord, my lord, there was a direction upon me.
Yes.
For my personal difficulties, my lord, I have already spoken to my learned friend. Lordship kindly grants me a week and a day's time. I will, my
Well,
lord, come back.
I
with
think he's
instruction.
in some personal difficulty. We can come back next week then. He's
My lord.
required to ascertain if that opportunity was given.
Yes, my lord, I will come back with the report. There is a direction upon me.
Who are you representing?
State Bank of India.
State Bank of India.
State Bank of India. All right.
Lord, I am representing the Reserve Bank of India.
Okay.
My lord, my grievance is against State Bank of India, who has sought to classify me.
Please come. Learned advocate representing State Bank of India seeks further time to take instruction. Stop. On such prayer, list the matter on 28th of January, 2/8.
Grateful, my lord.
Record appearances.
My lord.
I appear on behalf of the petitioner.
If it may please, my lord, I appear on behalf of the petitioner.
Yes.
My lord, if my lord may kindly take the order dated 20th December 2024. My lord will note, my lord, the state had been directed to obtain written instructions. My lord, I see that the state is not represented. My lord, this is the second such occasion. On the 20th of November, if my lord may kindly take that order. On that occasion too, the state respondents did not appear. If my lord may kindly, my lord, as a last chance, direct, my lord, that instructions be filed and circulated.
None appears on behalf of the state respondents. Stop. The said respondents were now the learned advocate representing the said respondents was to take instruction. Stop. Paragraph. As the instruction is not there before the court, comma, the matter cannot be proceeded with. Stop. Let instruction be obtained and the same be circulated to the learned advocates representing the respective parties by 24th of January. Let the matter appear in the list on 29th of January. Stop. Let this order be communicated to the learned advocate representing the state
My
respondent.
lord, may record as it's a last chance, my lord, if it may please, my lord. Very well. Deeply obliged, my lord.
Item 4 application, my lord. Item 4, Lordship, I am appearing for the respondent number 3. Lordship, I have just been brief in this matter. I have not received any instructions from my client. Only if this matter can be adjourned, Lordship.
Respondent number 3.
3, IDFC First Bank.
IDFC First Bank.
I have just
Reserve Bank.
Respondent number 1, Union of India, madam.
Union of Reserve Bank.
CSC, respondent CSC.
No, this is not.
CMC.
No.
Reserve Bank. Somebody was here in the last matter.
Reserve Bank is separate panel, I think, madam.
Yes. Somebody else was here just now in the earlier matter.
I told him, my lord.
Your grievances against the
You can see 3 and 4, my lord. What happens?
3 and 4. There is no 4, I see.
No, my lord. 2 and 3, my lord. 2 and 3. I'm sorry.
That means the Reserve Bank. Have you solved the Reserve
Yes,
Bank?
I have. Yes, sir. Yes, sir. Yeah. Going in.
None appears on behalf of the Reserve Bank of India. Stop. Learned advocate representing the respondent number 3 seeks time to take instruction. Stop. Paragraph. Let further notice be issued upon the non-appearing respondent, intimating that the matter will appear in the list on 22nd January.
Council is there, madam.
Who is the learned counsel?
Madam, the previous one, RBI appearing, madam. Just now, my lord.
Do you appear for the Reserve Bank?
No, let it be served upon our
Yes,
Reserve Bank
yes.
because the lordship knows that every matter.
Yes, cannot be said.
Let it be served.
Further notice, yes.
Will serve.
Acha. ঠিক আছে 22nd. Parties shall come ready with all necessary instruction on the adjourned date. Where is your service? Yes, service is taken on record.
Dada.
I'm for the petitioner.
Yes.
Dada.
Union of India.
Sure. For the respondent, man.
Which respondent?
Union of India and the railway man.
The outside, my lord, as my lord, the candid, my lord, application has been taken out, my lord, during, my lord, this matter was, my lord, moved during the vacation bench. At that point of time, my lord, it was learned, my lord, that the tender has already been, my lord, work order has been issued in favor of all Shorola Engineering. My lord, I have, my lord, filed a GA application, my lord, for addition of party of the Shorola Engineering. My lord, I have also served a copy of the GA as well as the writ, my lord. The affidavit of service is yet to be affirmed, my lord.
Did you take the collect the track report? The track report, did you
track
collect?
report, my lord, track report and my lord, service is yet to be effected, my lord. That's
all right, please come. Who do you intend to add as party?
My lord, the company in whose favor the work order has been issued.
It's been issued.
My lord, Shorola Engineering is the name, my lord. Your lordship will find it, my lord, from the application.
Yes, please come.
My lord, paragraph number 4 of my
The
application.
petitioner seeks addition of the successful bidder as party respondent in the instant writ petition. Stop. Copy of the application seeking addition is yet to be served upon the said party. Stop. Let service be effected. List on 22nd.
My lord, grateful.
Lordship, I am for the petitioner. Mr. Parthu Chakraborty lead this matter. He was out of station.
He was out of station. Has not come back
Adjourned for the week.
for the week. 23 matter. What is it about? Any idea?
My lord, it was regarding, my lord, electricity connection. A report was called for. Last date when, my lord, this matter was taken up, lordship wanted the report to be circulated. Now, my lord, we have got a copy of the report. Lordship also, my lord, indicated if either of the parties wish to, my lord, challenge the report, they are at liberty. I am representing private respondent, the respondent number 4. My lord, we have gone through the report. We don't wish to, my lord, challenge the report. Lordship can record my statement and keep it any day, my lord, convenient to the bench.
CAC, who is appearing? You are for the CAC.
Manmohan OCI.
Learned advocate for the petitioner seeks accommodation. Stop. Learned advocate representing the private respondent submits upon instruction that his client do not wish to file any exception to the report filed by CESC Limited. Stop. Next. List the matter for hearing on 24th of January.
Grateful, my lord. My lord, may I only seek, my lord, this, I am being led by Mr. Shumon Dotto, my lord. He is not available on 24th. Maybe any other date, my lord.
31st.
Grateful, my lord.
One, my lord, in this matter, my lord, I am appealing for the petitioner. There is a direction for service of to file a report, and liberty was also granted to file exception. But
Report not yet filed. What you are giving?
But I am.
That is a notice regarding.
But I am appearing for the respondent bank. Respondent number 1 to 6. But I am praying for a week's extension, to file the report.
Again week's extension. Why?
Some the advocate on record, it appears, it's some personal difficulty. Requested me, week's time, to file the report.
Last order, your lordship will find there is a direction for filing.
10th of December.
December. Please come.
And there is a notice. About notice it was mentioned.
Yes. Learned advocate representing the bank seeks extension of time for filing the report. Stop. Paragraph. On such prayer, time to file the report is extended till 24th of January. You'll be able to do it, isn't it? Today is 14th.
24th is.
10 days. No, আজকে হচ্ছে 15th. Today is 15th. 24th. I make it 27th. Acha. Let the matter appear in the list on 11th of February 2025. Stop. Exception to the report may be filed in the meantime.
And direction will also be there for service of the report. Well, otherwise,
yes, the report shall be served.
Yes, that otherwise,
Acha, copy of the notice.
In both the matters, 1 and 2 are the same matters, my lord.
All right. যেটা যেটার মধ্যে হবে সেটা তার ভেতরে ঢুকিয়ে দেবেন। Copy of the notice of the learned advocate of the petitioner upon the learned advocate representing CES Limited be written with the records. Same order in item 2 also. You are there in 2 also?
Grateful to your lordship.
My lord, item number 3 and 4, I am for the petitioner, my lord. The analogous matter, my lord. Last
3
occasion,
and 4?
Yes, my lord. 4 and 5.
3 petitioner নাম কি? Association and another?
My lord, item number 3, I appear on behalf of the writ petitioners, my lord.
Yes.
This has come up at our instance, my lord.
Right.
An order was passed, my lord, directing
Who
the
is your other side?
respondents. My lord, we had given notice pursuant to my lord's direction. We have given a
Who is
further notice.
appearing?
Mr. Mitra had mentioned the matter, my lord. They are supposed to file the report, my lord. They have served a copy of the report yesterday evening, my lord.
So you've got the report at least?
We have got the report, my lord, but this is, my lord, it pertains to jute packaging materials or the act, my lord. They are supposed to, my lord, 20% of the sugar is supposed to be packed in jute bags, my lord. That's mandatory central government notification.
I understand in the to be mentioned heading, you cannot make so many
No, my lord,
submissions. Where
only
is the report?
My lord, I have already submitted my report and I'm filing.
All I was praying, my lord, may it appear tomorrow as to be mentioned, my lord. We shall consider the report and come back. They also saying, yes, sugar is to be packed. 20% of sugar production is to be mandatorily packaged in jute bags. All I am praying for, my lord, under section 6, 7 and 8 of the JPM Act, let my learned friends, clients take action. They themselves, they have admitted that they have to take action against the errant sugar mills and the errant food grain mills like ragi, millet, pulses who are not complying with the JPM Act notifications. They have admitted, my lord.
Where is it admitted, please show?
Yes, my lord.
My lord, we are ready for argument. Matter is, a report has already been filed to my learned.
What is to argue? Because the grievance of the petitioner, as it has been portrayed, I do not know what is there.
Submit, my lord.
Yes, yes, you admitted the claim.
Yes, my lord.
My lord.
My lord will kindly come to paragraph 14 of the report, my lord. They have said who are the, my lord, who are the officers who have been entrusted under the act, my lord, with the powers. My lord, they have given the full table, which we had also annexed in a writ petition. So, my lord, let those officers take steps under section 6, 7, 8 of the JPM Act. My lord, may I hand over a copy of the JPM Act, my lord?
1 minute. Let me understand what your learned friend has got to say. Yes.
My lord, just please come at the synopsis of this writ petition that filed by my learned friend. That synopsis is, since 2013-14, they themselves admitted that the respondent union is issuing orders for mandatory packaging of 100% grains and 20% sugar in jute packaging materials. So that is admitted fact, my lord. And second one is, they have already admitted it that several errant sugar mills, so several errant sugar mills and non-government food grain mills are not complying with the order. And third point, my lord, is the respondents are empowered to take action against such errant sugar mills and non-government food grain mills. So what is my position, my lord? I am going to satisfy your lordship that this act, that is this jute packaging materials, may I take a water bag.
My lord, while my learned friend catches his breath, my lord will kindly see paragraph 15 of the report, my lord.
Yes, I have
My
seen
lord,
that.
last sentence, the respond numbers 1 to 5 have no authority to impose fine on the errant authorities, but can call for information and samples, enter and inspect and search and seize in terms of section 6, 7 and 8 of the JPM Act. I'm only asked, let my learned friends clients comply with this, my lord. Let them take steps under 6, 7, 8 of the JPM Act. They themselves, they're admitting. I've handed a copy of the JPM Act, my lord. Thereafter, we shall come back with for further orders before my lord. Let them comply with this part of the report, my lord.
My lord, kindly permit me to complete my submission.
What powers do you have to take steps against the errant sugar mills or something?
My lord, may I complete my submission?
Yes, yes, I'm inquiring from you only.
Stakeholders. First one is Indian Jute Mills Organization. Second one is Sugar Mills. Third one is Non-Government Food Grain Mills. And the fourth one is Union of India Ministry of Textile. So now, my lord, just please come at the act. And at first, please come at the prayer portion of this writ petition. That is
Yes.
page number 32.
Yes.
Are it in the nature of mandamus to issue commanding the respondent to disclose what measures they have taken under such and such and other relevant provisions of the JPM Act under Section 7 with Section 3 of the Essential Commodity Act against errant sugar mills and non-government food grain mills for not packaging 20% and 100% respectively. So now the next page, my lord, that is prayer is D, but are it and or in nature of the certiorari to issue directing the respondent such and such. And next page 34 is them to forthwith certify transit all records pertaining to the present case so that consignable justice. I have serious just objection on this point, my lord. So what is consignable justice?
Don't go to all those things. Tell me whether the provisions of the act are being complied with or not.
That this act is only deals with, we have a statutory power. We have no legal power to just implement those sort of things. We have done everything. We have sent all the letters. So just I am going to disclose all the facts.
Show me the provisions of the act where there is provision for penalty. Penalty for contravention.
My lord,
Section 9 is there.
Section 9, my lord, of that.
Yes, penalty for false statement offences of companies.
My lord, may I read it, my lord?
1 minute, let him place. Yes. Shall be punishable with fine which may extend to an amount equal to the double of the cost of the jute packaging materials. Section 9 is there with you?
JPM Act received the assent of the President to such and such. That is the statement of the object and reasons for the bill of the statement of jute packaging. Indicates that jute industry is agro-based, based on in addition to all these, my lord, it was intended to take 3 days. The considerable of the weighted by the parliamentary enactment. This is an statutory act, my lord. So we are just trying to just disclose all the facts to. That is page number 3, my lord.
Sir, will you please tell me what steps are you taking against the violators?
My lord, please come at page number 4, my lord.
Of what?
That writ petition, my lord.
Is it your case that there are no violations?
My lord, that is affidavit, the report.
Is it your case that there are no violations?
No, that is not my case.
Your case is there are violations.
My case is, my lord, we have done everything. And I'm going to satisfy, my lord, that please come at the page number 4, report filed by us, my lord. I'm just going to satisfy your lordship that we have taken all the actions which we can take.
So is it your case that you have done whatever is required to be done, thereafter you cannot do anything, even if there are violations? Is this your case? So you cannot do anything?
My lord, let me explain that point.
There is no question of explaining. Say whether you have powers to take steps against the violators or not.
No, my lord, we have no power.
You have no power. What is Section 9 therefore? What is this penal provision?
As far as the decision on mandatory packaging is concerned, my lord, that decision is taken by the central government on the basis of.
You were appearing for?
I am appearing for respondent number 1, 2, and 3.
My lord, Ministry of Textile, Jute Commissioner, and
1, 2, and 3. 1 is the Union of India, so you can take steps. It is your officers.
My lord.
Then, and you say you do not have any powers.
My lord, we have no legal sanctity to act, and we have just power to issue notices. We have already just, that's why JPM just empowers the central commitment to constitute a standing just advisory committee. That advisory committee just advises us. On the basis of that advice, we take actions, my lord.
What over here? What is the recommendation of the advisory committee?
My lord, these are the existing level of usage of jute materials. That is matter related to. Second one is the quantity of raw jute available. Third one is the quantity of jute materials available. Then the protection of the interest of the persons engaged in the jute industry and in the production of raw jute. And need for the just continued maintenance of jute industry. Then the quantity of the commodities. So
I placed and said they have admitted that they will default, so they should take steps. They themselves, they are saying they have the right authority to take steps. So
sir, I am not satisfied with your submission that your authority doesn't have any power to take steps against the violators.
My lord, we have only statutory power.
So what else? What power? What else power do you require? It is only the statute from where you derive your power.
My lord, that is section 6 is power to call for information and samples only.
What about section 9?
The 9
Please come. Report filed by the Assistant Director within bracket cost.
And 10 also, my lord, section 10 also.
By the learned advocate representing the Union of India is taken on record. Stop. Copy of the same has been circulated. Stop. The parties are directed to come ready with with their arguments. Stop. List on 24th of January. You please come prepared as to what are the penal powers that you have and what steps you can take against the violators. Have you followed? Exception to the report may be filed in the meantime if you want.
Well,
if you
I don't want any exception.
very well.
I'm saying implementation of this.
Yes.
To may come as a to be mentioned only.
No, certainly not. In a to be mentioned, you cannot expect hearing to take place. And if this practice is started, then the list will not be over, ever. Yes. 4.
My lord, I am appearing on behalf of the respondent number 4 and 5, my lord, the analogous matter, my lord.
Respondent numbers 4 and 5.
My lord, petitioner for 4 and 5, my lord.
You are for the petitioner.
4 and 5, my lord. Analogous matter, my lord. My lord, I mentioned the matter before your lordship for upgradation. Due to heavy list, your lordship disallowed the mentioning, my lord. That is why I am praying for releasing the matter so that I can take charge before any other.
But tell me one thing, whether this bench of determination, this is a cooperative society matter?
No, my lord. It is a operation of bank account, my lord.
Bank?
Yes, my lord.
It's a cooperative bank, but
it's a cooperative bank. Yes, and what is your prayer before the authority?
My lord, bank authority is not allowing us to operate our account after changing the account holder, my lord.
What happened, my lord? There's a change of guard in the management of the society, and thereafter the new authorized signatories are required to submit their KYC. They have submitted the copy of the resolution and the particulars of the authorized signatories, but not the KYC of the authorized signatories. In absence of
you have anything to keep it on record so that I can pass orders?
My lord, I have an instruction from the bank. But
I'll direct them to file the KYC details and so that they can operate the matter.
Bank is the cooperative society is comprised of rural women, my lord. They are not very familiar with the formalities, but unless the KYC is submitted, my lord,
please give. Please give.
This is the instruction, my lord.
Please come. The petitioner seeks for a direction upon the bank to permit them to operate the bank account. Stop. Learned advocate representing the bank submits upon instruction that the bank officials contacted the petitioners and requested them to submit all papers in support of change of operation, change of mode of operation of the bank account. Stop. The petitioners submitted the resolution adopting the decision to change the office bearers. But the other documents, namely the specimen signature and the KYC details of the bank operators, are yet to be submitted. Stop. Paragraph. It will be open for the petitioners, the representative of the petitioners, to submit before the bank the specimen signature and the KYT details of the bank operators before the bank. Stop. Paragraph. Within a period of 2 weeks from the date of compliance of all necessary formalities, comma, the bank shall permit the representative of the petitioner to operate the bank account. Writ petition disposed.
Next
The
matter,
statement
bracket
of
number 5.
facts. Yes.
It's another bank, but Indian bank. He is representing the
Answer.
bank.
The instruction forwarded by the manager in charge of Bolagaria CC Bank Limited, signed on 2nd January 2025, be written with the records.
Item number 5, Lordship, I am appearing on behalf of respondent number 1 and 2. Lordship, day before yesterday, I have intimated about this matter. That's why I am appearing. Copy of the writ petition not received, Lordship. Praying for not today.
Just serve.
Given from the bank.
So, affidavit of service, madam.
Give a copy to her so that she
Yes,
can
I
take
can.
instructions and come back.
Yes, Lordship. Kindly.
Madam, they'll consider our case after submitting all documents. Let the pass, whatever we pass, madam. Otherwise, madam, bank account is freezed, my lord. The salary of the account employee would not be done, my lord.
The thing is, if there is something else required to be done,
We shall submit if it's possible to us.
Acha, please come. The petitioner prays for a direction upon the bank to permit the representative of the petitioner to operate the bank account. Stop. Paragraph. The bank is directed to intimate the petitioner the formalities that are required to be complied for operating the bank account. Stop. Within a fortnight from the date of compliance of all necessary formalities, the bank shall permit the petitioner to operate the bank account. Writ petition disposed. Record your appearance. Where is your wakalatnama? Filed it? Very well. 6.
In 6, my lord, I am for the petitioner, my lord.
I am for the respondent in this matter.
This is the affidavit of service, my lord. My lord.
Regarding this matter, so far, I have received the brief just today in this matter, and I have learned this in this brief that as per the application of the petitioner, bank has disbursed the amount. So, Lordship, it is necessary to take instruction from the bank to file.
1 minute.
My lord,
Central Bank, did you serve?
I have served, my lord. I have served. The fact is that, my lord, I am the passed out student of Bachelor in Dental Surgery, my lord. Presently, I am pursuing internship in Manipal University. I was entitled to obtain one loan under West Bengal Students Credit Card Scheme of total rupees 10 lakhs, my lord, out of which I obtained 5,64,000 of loan. At that point of time, there is a litigation pending before the Honorable High Court at Karnataka between some other students and the concerned university. For that reason, university reduced initially the amount of course fee. Thereafter, university received favorable order from that litigation, my lord. It exceeded the course fee, and I was compelled to approach before the respondent for further a loan of 4,64,000, which the bank refused, but not in written format, my lord. That is my only grievance. I will be appearing in the examination in 31st of January, my lord. Before that, if I will not get the 4,64,000 amount, I will not be able to attend the examination. That is my only grievance.
But the bank is required to be represented.
And this is the notification of the upcoming examination.
This is the service was made in September.
Yes, my lord.
Thereafter, did you serve the matter that you upgraded?
No, that is not served, my lord.
Then how will the other side get to know your matter was there at the bottom of the list?
My bank has representing, my lord.
Bank is not represented. He is representing the Union of India. And why have you made the Union of India a party? I do not know.
Central Bank is the party, my lord. That is why I have made.
Central Bank is a different authority. Union of India is a different authority. Union of India does not have any role to play. You could have at least implemented the state government, because the loan sanctioning authority is the state government. It's according to their directive that the bank is Union doesn't have any role to play over here.
Lordship, one thing, as per their application, I have read out the petition, as per their application of 23rd September 2022. Lordship, he has approached the bank for a loan of rupees only 5 lakh something, and bank has disbursed.
Yes, initially.
Please wait. Yes.
And thereafter,
He wants further loan.
further,
Yes.
in this respect, it is necessary to take instruction.
He's representing the bank, probably, my lord.
Are you representing the bank?
I'm representing
Central Bank of India
Central Bank.
and the Union of India?
Both.
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 Then it's nice. Then you take instruction as to.
Lord,
Yes,
it
my
is
lord.
necessary to take instruction.
And this candidate will sit for the examination immediately. So very urgent information is required.
Amount has been paid as per their application.
Try to understand. He wants additional loan.
Additional loan, Lordship. In this respect, it is necessary to take what is the rules and what is the formalities.
Yes, you take instruction with regard to that.
Lord.
Come back on Friday to allow the learned advocate representing the bank to take instruction in the matter. List on 17th.
Seven, this is my application. My lord, I have given a notice for my lord to the state. Yeah, noticed.
Yes.
My lord, this is a matter relating.
Mr. Nilotkar Chatterjee is appearing, my lord. He is on his.
For whom?
For the state, your lordship.
Yes.
He is on his legs, my lord.
You must be assisting him. Who is assisting him?
I'm not briefing this man.
Who is assisting him? Are you aware?
Mr. Tonal Chakravarti is assisting, and Mr. Tonal Chakravarti is assisting, my lord, and he.
Then get hold of him. Yes.
My lord, I am challenging the order, my lord, which is in the nature of a communication, which is annexed in P9, my lord.
Communication by whom?
To me. My
By
rejection
whom?
by the state authority. My page 53.
53, yes.
Yes.
Senior officer law.
My lord. My lord, I made an application to regularization of my prayer that has been rejected, my lord. My lord, what happened? My lord, earlier.
Show the order of the division bench.
Yes, my lord. My lord, order is my lord 19 to 22. But this case has a history because, my lord, after the division bench order, my lord, they have given an appointment to the, my lord, there is also order of a learned single bench. They preferred a review application. But they rely.
Appeal court did not allow your prayer.
Yes, my lord.
Now?
My lord, what happened? My lord, the case is that, my lord.
What is your prayer? What is your prayer?
My lord, my prayer is that, my lord.
Not ready with your prayer?
Yes, my lord.
What?
My lord, my prayer is that.
You are looking through the prayers and then making submission.
No, my lord. No. My lord, my prayer is that rescind order, pass a rescind order afresh. Why I am saying, my lord, prayer A. Why I am saying, my lord, kindly come at page 59. That is review, my lord, filed by the state government before the Honorable Justice Sabyasachi Bhattacharya, where my lord Justice, my lord, made a observation, my lord, that is, my lord, paragraph 13, my lord, page 53, and start with, my lord, paragraph 13, my lord, page 58, paragraph 13. My lord, what happened, my lord, I made a application for regularization. After, my lord, the division bench order, my lord, they have rejected my claim. My lord, prior to that, I filed a writ application. My lord, when the date was fixed for hearing of the writ application, prior to that, they have passed the order. My lord, thereafter, Honorable Justice Bhattacharya, my lord, passed an order directed them to consider my representation because why the equal treatment given to the third person. My lord, thereafter they filed a review application. They stated come with they armed with this division bench order. My lord, after that, considering that my lord Justice Honorable Justice Sabyasachi Bhattacharya passed this order. My lord, paragraph 13. I like to my lord, draw kind attention because my lord, division bench order passed. After that, my lord, they have given an appointment to the third person, and who is my lord on a same my lord, having been same qualification. Despite of that, my claim has been rejected.
My lord.
Where is the rejection of your claim?
My lord, page 53.
Page 53. The division bench's order was there at that point of time.
Yes, my lord. Thereafter, that point of time, division bench order was there.
Yes.
But my lord, what happened? Thereafter, they have my lord kindly come paragraph 13 of the page 58. My lord, because what happened? One person, my lord, who is standing on the same footing, they have given a my lord 68 years, my lord, for continue for his service. Relying upon that, I made an application. My lord, they claim rejected, my lord. That is after that, my lord. That is my lord, recorded in my lord, order, my lord, in a review application filed by the state government. My lord, paragraph 13, my lord. May I read it?
No, paragraph 13, I have read it.
My lord, petitioner having been unequal treatment. My lord, unequal treatment being given to the third person.
Listen, a notice has been published, page 62, for appointment of permanent Muslim marriage registrar.
Yes, my lord, that has been yesterday, my lord, has stated the notice. Because because the matter was before your lordship, the formation of a committee, one person preferred a writ application for my lord, qualification of committee member.
Yes.
My lord, that notice has been stated. I am not my lord.
Notice has not been stated. I do not.
No, my lord, perhaps my lord, appointment is my lord, postponed for till 2nd February.
No, you have got nothing to do with that. You want the matter to be posted after 2nd?
Yes, my lord.
After 2nd? What is your instruction?
My lord, I do not have any instruction. My lord, may the matter be passed over till 2, my lord. And
লিখুন তো, learned advocate for the petitioner, prays for posting the matter after the what is the date?
My lord, 2nd February. My lord, I have been
2nd
instructed.
February is a Sunday.
My lord, after till the 2nd February, they have told my lord.
No, you are making wrong submission.
If my lord desire, my lord, kindly make it tomorrow. I shall bring with the order.
No. After list the matter on 10th of February.
Obliged to my lord. And my lord, my lord, prayer, my lord, because my lord, the person who has given a my lord appointment, my lord, 68 years, my lord, despite of the fact that appointment has been given, my lord, after the passing of a division bench order.
I am not passing any order today.
Obliged to me.
Bas, on the prayer of the learned advocate for the
Obliged.
petition. Yes.
May I please, my lord. My lord, I appear on behalf of WBSCTCL in this matter, my lord. I was directed to file and report. May I hand over the copy of the report?
Please. Petitioner is there or not?
Madam, I have served them.
You are for the petitioner?
Yes, my lord.
Received the report?
Yes, my lord.
Yes. What is your submission?
Madam, we kindly see, my lord, that there are two, a sketch map I have given. I got the sketch map. That next page, man.
Sketch map. Yes, sketch map.
One is a field report, another is a printed sketch map of that field report I have given, man.
Yes.
I kindly see there is an arrow given land of Momota Guo.
Land of
Man, subsequent to that, man, we see there just beside that Momota Guo is using this railway land, man, for his for our ingress and ingress in the property. Man, there is an existing pole, man, just on the right and left hand side, man, we see house of Shamol Ghosh. This is the existing pole which is there, and subsequently, my lord, there is a proposed location for new pole to the house of Momata Guha, mana, that is over the land of Subhash Bishwas and Manoj Kumar, Manoj and Saroj and Krishna Saroj, mana. The difficulty is that, mana, they are objecting and there is no other alternative way. Mana, the railways are also not party. I don't think, mana, the government will allow, mana, the WBCL, ACTCL to implant poles and give connection. Mana, this is the difficulty we are facing, mana.
In that case, it has to go before the district magistrate.
My lord,
Then section 3 of the walk and
please, my lord. My lord, the private respondents, my lord, are objecting. It is not the case of the private respondent that they are either the owner or the occupier of the premises in question. The premises in question is the petitioner is the sole owner of the premises in question. The objection on behalf of the private respondent seems to that they are objecting the overhead line only because of the fact it is their claim that by erecting that overhead line, the petitioner will encroach upon the land of the private respondent. That is their sole sustenance of objection.
You are not here to interpret the objection of the private respondents. They can make submission,
my lord,
as to what they want to object and the manner they want to object.
My lord.
A sketch map has been brought on record. It appears that your land is absolutely landlocked.
My lord.
Where is your entry point? Your entry point is the railway land. Do you have any other entry?
Yes, my lord. I am passing through the railway land, my lord. That is, my lord, kindly, I have one authority, my lord, that right to way, my lord. The right to way has to be interpreted in terms to section 43 of the Electricity Act, my lord.
Yes.
My lord, now only because the private respondents is not permitting any right to way of the electricity line, that does not permit, my lord, the electricity authority, the licensee company, not to connect electricity.
The electricity company will go there and fight. What they will do?
My lord,
you have to come up with a plausible solution, whatever is there in law.
My lord, there is a post, my lord. From the post, my lord, the electricity line can be drawn up, my lord. My lord,
how?
My lord, the overhead line,
yes,
my lord.
The objection is
yes,
coming.
My lord, that objection is not sustainable, my lord. My lord, kindly come to my lord. My lord, one thing, my lord, kindly have a look on the electricity rules, my lord, of 2005.
The re-inspection report signed by the assistant engineer and station manager, Dadpur Customer Care Center, WBSEDCL, on 9th December 2024 is placed before the court. Stop. It appears therefrom now a drawing has been annexed to the said report, wherefrom it appears that the petitioner gets access to her land through the land of the railways. Stop. For the purpose of effecting electric connection to the land of the petitioner, overhead wires are to be drawn. Overhead wires are to be drawn over the land of the private respondents. Stop. The same is being objected to by the private respondents. Stop. Next. In view of the above, the matter is referred to the district magistrate Now, DM is not a party. District Magistrate Hooghly, for taking a decision with regard to the alternative way, to DM to find out an alternative way for providing electric connection to the land of the petitioner. in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop paragraph. The district magistrate, Hooghly, shall afford an opportunity of hearing to the petitioner and the private respondents prior to arriving at a decision in the matter. Stop. The writ petition stands disposed of.
Grateful.
There's another owner, Manoj Saroj, which is in the drawing, it is there. But he has not been made a party. His father, Fulchand Saroj, has been made a party. So Manoj Saroj is also required to be, and he had given a written representation for, and his name is recorded in the drawing, Manoj Saroj.
Manoj Saroj, I can see.
Your Lordship, but he is not a private.
You are Subhash?
Subhas, and Subhas Vishwas and Krishna Saroj. But
All
Manoj
right.
Saroj is my brother and he's also co-owner of that property. So he
Very well.
needs to be.
যেখানে বললাম না private respondents. বললাম opportunity of hearing.
Other co-owners.
কি বললাম? Petitioner, comma, the private respondents and all other necessary parties. ঠিক আছে? Leave is granted to the advocate of the petitioner to communicate this order to the district magistrate Hooghly for necessary compliance. না ডিএম পার্টি নেই, লিভ দিতে গেলে প্রবলেম আছে, আবার সার্ভিস করো আবার এ করো, লেট দ্য ডিএম টেক স্টেপস.
আই এম গ্রেটফুল ম্যাম.
I am in this writ petition, Miller. I am challenging an order. I am challenging an order passed by the appellate authority in an appeal from an order of the West Bengal Medical Council, which, Miller, has removed my name. I am a gynecologist by profession, which has removed my name from the rolls of the Medical Council on the ground of infamous conduct in my profession. Now, Miller, I have also challenged the vires of certain sections and rules, but for the purpose of interim order, I shall not address your lordship at all on that, because I know there is a presumption in favor of constitutionality. And Miller, I will not trouble your lordship with the facts of this case. I will not controvert them at this stage. I'll take the facts as they stand. I'll take the factual situation as alleged by them. My submission is that assume that I am a very bad person or a bad doctor, but even then I am entitled to due process. And in this case, Miller, due process and provisions of statutes have been violated at every stage, including principles of natural justice. Miller, kindly come first to the charge sheet, which is at page 83. It is dated 15th of January 2024.
Yes.
On behalf of the West Bengal Medical Council, I give you notice that information and evidence have been laid before the council, by which, on the basis of the complaint and further inquiry, the following charge has been made against you, namely, during the antenatal period of treatment of Ms. Moumita Shadukan, you did not make any psychiatric, neuromedicine, endocrinology referral, though you had noted the patient as that of psychoneurosis. You had performed an irrational LUCS on her on 28th of October 2019 in Megacity Nursing Home, while her EDD, expected date of delivery, was 21st of November 2019, and there was no proper indication of CS as the patient was not in labor. You had left the nursing home after the LUCS without leaving any official intimation to the nursing home authority and could come back late only to declare the patient dead. You had tried to mislead the Penal and Ethical Cases Committee of this council by claiming that you had handed over the charge of the patient to Dr. Arindam Majumdar, which Dr. Majumdar denied in writing before the committee. The autopsy report suggested that the patient died of massive internal bleeding, but there were no postoperative notes in the BHT, that is bedhead ticket, from 9:40 a.m. to 3 p.m. indicating total lack of post-operative monitoring, which could have diagnosed the situation and saved the patient, and that in relation thereto, you have been prima facie guilty of infamous conduct in a professional respect. And I am directed further to give you notice that a meeting of the West Bengal Medical Council will be held to consider the above mentioned charges against you and decide whether or not they should direct that your name be removed from the register of registered practitioners pursuant to section 1725 of the Bengal Medical Act 1914. Now, Millard, I'm pausing here for a moment. Millard, here even the show cause notice shows a prejudgment and a closed mind, because Millard, under section 25 of the Bengal Medical Act 1914, the authorities have an option, the Medical Council has an option of either removing my name from the register or issuing a warning. So at the show cause notice stage, both the options are assumed to be open for the Medical Council depending on my defense. But Millard, in the show cause itself, they rule out the warning part and go on the basis of the higher penalty, that is, Millard, removal of my name. Be that as it may, Millard, that is one of my submissions, Millard. Then, Millard, kindly come to the reply to this. The rest, Millard, is all procedural. Kindly come to page 85. I respond to the show cause notice, to the charge sheet, rather. During the treatment of Srimati Maumita Sadhu Khan, I did not advise for psychiatric or neuromedicine or endocrine consultation because she was not having the said medical problem during this pregnancy. She was taking occasional psychiatric treatment before pregnancy, which was revealed during taking routine past history, as she was suffering from infertility and was receiving torture from the family. I would definitely ask for consultation of respective specialty if there would have symptom or sign of the disease. For example, on 25th of September 2019, I advised her to consult physician when she had fever. In my opinion, decision of LUCS on 29th October 2019, expected date of delivery such and such, was rational because this was pregnancy after treatment of infertility for 5 years, and the patient came to my chamber on 28th October 2019 with complaint of dribbling for vagina, which she was carrying 37 weeks pregnancy. So she was admitted and kept under observation. Next day morning, dribbling increased and she was in early labor. So considering valuable pregnancy, LUCS was done. I left the nursing home as usual, like other routine cases, long after shifting the patient to the ward, throwing the patient to her husband and talking among themselves in good condition. I did not make any official confirmation because I was not leaving the station. And I went to see my old mother to a house, only 30-40 minutes distance, and keeping the communication open over mobile. For any emergency, I could attend the patient in time. In fact, this much time might be required if I would start a hysterectomy operation after this LUCS operation. Definitely, I would make official information if I would leave the station for long distance. I did not neglect the patient because I kept all communication open, and when I got information from nursing home, I immediately sent a qualified, experienced anesthetist who informed me that the patient is quite well and no need for me to go to the nursing home at that time, and he noted the stable condition of the patient in the bedded ticket. In fact, I rushed to the nursing home quickly around 4:15 p.m. when I got the information again that the patient is complaining of chest pain. I informed the ward RMO to shift the patient to ICU. I started treatment along with ICU RMO and ward RMO and other doctors who were present there at that time. Meanwhile, I consulted with her husband also in ICU. This is wrong information that I reached there after the patient is dead. I have never tried to mislead the Penal and Ethical Cases Committee because myself and Dr. Arindam Mojumdar, Gynae, do group practice in Barashat. Whenever any patient of us need any help, we communicate with each other by phone and we attend the patient. In this case, I went to see my mother, which is not so far, with telephonic information that if needed, he will attend the patient. Afterwards, I did not inform him as the anesthetist informed me that the patient is stable. During the second incident, I was at station and myself attended the patient. Dr. Arindam Mojumdar is right to say to the committee that he does not know about the patient. I think that the patient was properly attended because after completion of the operation, I was in the nursing home for above 1 hour more, and I checked the patient before leaving the nursing home. I did not make any note in bedhead ticket because the patient was all right. After that, the patient was taken care by the on-duty nursing staff and ward RMO. time to time as per my instruction. That's why they could communicate me when the BP of the patient became low. There was no note in the dated ticket during the period from 9:40 a.m. to 3 p.m. because there was no problem of the patient during that period. When the problem arose, it was noted in VHT at 3 p.m. The patient was cared time to time. That's why nursing home could communicate me, and I sent one qualified and experienced doctor to see the patient immediately, who found that the patient is stable. The stable condition of the patient is also confirmed by the complainant, Mr. Sanjay Sadhukan, which is evident by his statement in his complaint letter to the Registrar, West Bengal Medical Council, that at 3 p.m. he saw the patient quite normal, and so he refused to shift the patient to ICU. After that, he was sitting beside his wife as it was visiting time, during which time patient complained chest pain when RMO immediately attended the patient and patient was shifted to ICU. I think if you would allow the patient to shift to ICU earlier, there would be better monitoring. I think failure of diagnosis is not negligence. I am working in this capacity for last 40 years with good reputation and sincerity wherever I have worked. Further, I am to inform that I operated the patients in West Nursing Home at Barashat, having good nurses, both ward RMO and ICU RMO and all sorts of critical care facilities at ICU. The team of the operation was good. I have 40 years experience, etc. Willard, this is my defense. Now, Willard, kindly come to the order passed by the West Bengal Medical Council after this, dated 13th May 2024 at page 88. Millard, a cryptic, unreasoned order. It says, sirs, this is to inform you that the West Bengal Medical Council at its extraordinary meeting held on 9th of May 2024, after considering the charges as framed up, we did this office notice of inquiry dated 15th January 2024, which I have already placed, as was communicated to you for hearing of the charges, found you guilty of infamous conduct in a professional respect, and decided that the name of Dr. Gauranga Kumar Bhatak, registration number such and such, be removed from the Registrar of Registered Medical Practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of the order in this respect under Section 25A2 of the Bengal Medical Act 1914, and your name has accordingly been removed from the register from the date of communication of this order. Your attention is being drawn to the provisions under Section 26, which reads us under which I can prefer an appeal, which I did. Now, Millard, there cannot be a more unreasoned order than this in respect of such a serious penalty that my name as a medical practitioner is being removed from the rolls of the council. There is no discussion. Now, Millard, the whatever transpired in the alleged extraordinary meeting held on 9th of May 2024 is not disclosed to me at all. And that is being referred to. And Willard, I would say an ipse dixit on the part of the respondents, a one-line communication that your name has been removed. No discussion on what act would constitute infamous conduct on my part, because there is a huge body of case law on what would constitute infamous conduct, and the courts have said that even mere negligence will not constitute infamous conduct.
Yes.
Now, Willard, I prefer an appeal against this order to the Principal Secretary, which is at page 89. I will not trouble your lordship with my appeal petition. Kindly come to page 91, which is the order of the appellate authority, being the Principal Secretary, on an appeal preferred under Section 26 of the Bengal Medical Act. This is an appeal under Section 26 of the Bengal Medical
Please
Act.
don't read the whole thing because it appears to be a detailed one.
I will not kindly, Millard, take a portion of it. Kindly come, first of all, to, because, Millard, the initial paragraphs, in fact, almost the whole of the order only records what various committees have said. But even then, kindly come to page 93, capital A, because this is important for my purpose. Internal page 6 of the order.
Yes.
In view of the above observations, the Penal and Ethical Case Committee 5 found that Dr. Gauranga Kumar Bhatak not only negligent in the conclusion they come to is Dr. Bhatak is negligent in the pre as well as post-operative management of the patient, Mrs. Sadhu Khan, which led to her untimely death, etc. But he was trying to mislead the committee. Now, Millard, this finding of negligence is not compatible in law with a finding of infamous conduct. And I am covered by authorities, I can come to that. This narration of history goes on. So I will not trouble your lordship with that. Kindly come, Millard, after it ends at page 95, capital A, or Millard, page 96. In fact, come to page 96. Up to small Roman 1, it is merely narration of what earlier committees had said. But I wish to make one comment that these reports of the Penal and Ethical Case Committee, experts, etc., were never communicated to me, even when even after passing of the order. This, in fact, that is already there. In this respect, kindly come to page 97. Millard, it was only on 29th of May 2024 on my request that my request made in 17th of May 2024, they responded by furnishing the opinion of the expert committee. Then Millard, the others, they say that P&D committee is already part of the deposition, so they are not furnishing it separately. But this comes 29th of May 2024, much later. So Millard, they are relying on expert committees, P&D committee, etc., without Millard supplying these materials to me at all and without affording me an opportunity of rebutting that. Now, Millard, kindly come to, after they end this narration, kindly come to page 96. The only portion which seems to be their order. The postmortem report suggests death was due to the effect of postpartum hemorrhage, antemortem in nature. It is evident from the evidence of Sri Dibendro Ghosh of Megacity Nursing Home Private Limited, taken on 25th July 20, paragraph 34, 34 and 35. I am reading 35. It is evident from the evidence of Sri Dibendro Ghosh of Megacity Nursing Home Private Limited, taken on 25th of July 2023, that the appellant Dr. Ghatak left the nursing home in the morning around 10:30 a.m. The evidence of Dr. Arindam Majumdar clearly suggests that the anesthetist attended and supportive treatment was given to the patient, and the patient was shifted to ICU around 4 p.m. to 5 p.m. Then, well, the next sentence is very significant in a matter of this nature. So, in all probabilities, the appellant Dr. Ghatak was not present at the nursing home after 10:30 a.m. till the patient shifted to ICU at 5 or 5:10 a.m. Therefore, Millard, first of all, I have clearly indicated that I arrived much before she was shifted to the ICU, and I treated her in the ICU. But even apart from that, they themselves say that in all probabilities. So the order of removing me, or rather confirming the order of my removal, is based on a probability. The evidence of Dibyendu Ghosh of Megacity Nursing Home suggests that there was no official intimation regarding his leaving the nursing home, and on the other hand, intimation was given to Mr. Ghatak time to time, Dr. Ghatak time to time from the end of the nursing home, but Dr. Ghatak did not visit the patient before shifting her to ICU. The appellant herein, or his assistant, Dr. Devashish Ghatak, MBBS DGO, did not come to the nursing home to see the patient in spite of several intimations by the RMO in a period of about 6 hours in the immediate post-operative period, which was clearly professional medical misconduct. Millard, in law, I join the issue here because the law is that even assuming there is negligence, there is no infamous conduct, which tantamounts to misconduct. If the present appellant would have been present at the nursing home at the very first call, then the so-called postmortem massive internal hemorrhage could have been managed and untimely death of a young mother could have been saved. Then, Millard, my defense is not discussed at all. Paragraph 37, they only say the submissions made by the appellant in support of his innocence have got no leg to stand upon in view of the evidence on record, post-mortem examination, report, observations of the experts, and therefore the appeal fails. Accordingly, the present appeal is hereby dismissed. Well, I assail this order on the ground of not disclosing any reasons at all for affirming the order of the West Bengal Medical Council, and Millard, relying on materials not supplied to me. And even Millard, the appellate authority constituted an expert committee whose report was never made available to me, apart from the question that it's my submission that the appellate authority has no jurisdiction under the Act to form an expert committee at the appellate stage. Now, my lord, the non-application of mine is further evident from para 39. Consequently, the order decision impugned passed by the West Bengal Medical Council dated 13th of May 2024. This is not the fact, Miller. The order is dated 9th of May 2024, communicated on 13th, because they say that the decision was taken on the 9th in the extraordinary meeting of the West Bengal Medical Council for removal of name of Dr. Gauranga Kumar Ghatak, having registration number 36043 of WMC, from the Register of Registered Medical Practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of that order under Section 25A2 of the Bengal Medical Act 1914. Miller, I submit therefore, Miller, that both the orders, the West Bengal Medical Council order and more the appellate order, suffers from violations of the principles of natural justice because materials relied upon not supplied to me. Secondly, both the orders in my humble submission are devoid of any reason. Thirdly, Millard, assuming there is a finding of negligence, which the appellate authority records as part of the findings of the P&EV committee, negligence does not and cannot amount to, Millard, infamous conduct in the profession as contemplated. And there I am covered by authorities. If your lordship wants, Millard, I shall cite those judgments.
But not today, at least,
Not
because
at the motion stage. That's why I
cannot be done.
Millard, in the circumstances, I am praying, Millard, that the order may be kept. In fact, I'll also rely on a judgment of this honorable court in a bench presided over by Justice Mukherjee, of which your lordship was also a member, and your lordship delivered a separate concurring judgment, but not today. Millard, in the circumstances, I am praying that this order of removing me may be kept in abeyance, because Millard, if ultimately the writ petition fails, I can serve out the rest of the order, and my name can stand deleted for the full period of 2 years. That can be made up. And in that judgment of the division bench, your lordship has been pleased to observe that removal of a doctor's name ultimately, if illegal, ultimately does not serve any purpose, because it is the patients at the end do suffer because the doctor comes back after 2 years. So I submit, Millard, on the principles of prima facie case and balance of convenience. The writ petition may be heard out, but the order may be kept in abeyance for the time being. And Millard,
anybody for the state?
State is meeting, Millard, on the last occasion, your lordship directed to serve a copy of this petition.
Yes, that is for the purpose of the challenging the vires. That
I'm
apart,
not addressing the
yes, he has not addressed, but then the appellate order by the principal secretary is under challenge. So the state is required to be represented.
So for and Millard, before my learned friend begins, I missed out a point. I'm grateful to my learned junior, which may also my case, that the West Bengal Medical Council, I've stated so in paragraph 26, on the day on which they called me, did not have the quorum at all to hold the meeting. There were 5 members present, whereas the prescribed quorum is 7. Those are my subjects.
You are for the council,
Yes.
right?
Yes.
The initial order passed by you, affirmed by the principal secretary. I will certainly hear you. You are representing? Who is the respondent number 4? All right. Husband of the victim, lady. Will you please send somebody to inquire who is appearing for the state, so that a phone call can be made and the council can come or anything? Was the GP served?
GP has been served, I'm instructed.
Let me see a copy of the letter.
For W Medical Council.
GP service?
GP service.
Where is the GP service?
Government.
That is not the service
Government
upon.
pleader has not been served.
This is the reason nobody is here.
Yes, I appreciate, Millard. The government pleader should have, the parties have been served, but the GP ought to have been served.
Otherwise, nobody will appear for the principal secretary till. In that case, prior to hearing him, I would like you to serve the GP and come back.
Very well, Millard. We'll serve today itself. Your lordship may
Yes.
take it up tomorrow.
No, within 24 hours. The matter is pending from 24.
Yes.
It has been upgraded on
Let it be
mentioning.
on, today, I think is Wednesday. Let it be on Friday, Millard, if possible.
Friday it will not be possible. I'll keep it on Tuesday next.
Tuesday. Very well.
Let service be effected. Please come. Heard detailed submission by the learned senior counsel representing the petitioner. Stop paragraph. None represents the state. Is he there for the state?
No.
No. Acha. None represents the state. Let notice be served. Now let a copy of the writ petition be served upon the learned government pleader. And the learned, but the AG was directed to be served because
Yes, AG was served. AG has been served, the service is here.
If the AG is served, then at least somebody should be there.
Yes, Millard, AG has been served.
Inquire from the AG's office who's appearing.
Let a copy of the petition be served upon the government pleader.
Government pleader intimating that the matter will appear in the list on 21st January 2024. Stop 25. Acha. The petitioner press for an interim order staying the operation of the order passed by the Principal Secretary, Department of Health and Family Welfare, being the appellate body of the order passed by the West Bengal Medical Council. Stop paragraph. Learned advocate for the state shall make submission with regard to the interim order sought for by the petitioner. 21st. Your affidavit of service should be on record. Please
Yes,
pass on.
we shall file it on the next day.
Yeah.
Millard.
On the next day, today it's not ready.
Millard, that the service has taken place. Earlier affidavit of service has been filed, but some service were remaining which have been done. That affidavit of service is not ready. I can file in the course of the day, if your lordship.
All right. Further affidavit of service shall be filed in the course of the day.
Lordship.
ওইটা ফেরত দিয়ে দিন, এফিডেভিট অফ সার্ভিস করে জমা দেবে।
Report. Petitioner is on this. I appear on behalf of the CSC in this matter. I was supposed to file a report, Madam. May I file the report?
I am for the petitioner.
Before my senior begin, the counsel appearing for the private respondent, he is attending some litigious committees. Specifically, at the email level. If a lordship can keep a note this.
My lord, it is a matter of electricity. My lord directed to
The
inspect.
learned counsel is not present. What can be done? Give me your report or something.
They are
I've
not,
given the report.
they are even not
In spite of an order of
this court.
Directing the police authorities, my lord, we have inspected the meter room, but my lord, we kindly turn to the second photograph, and that is the tin shaded door, my lord, wherein, my lord, we wanted to inspect the actual site because they have applied for commercial meter in respect of iron goods. That was not allowed, my lord. The police was there, but the police could not give free access, my lord. My lord will direct us to re-inspect and come back, my lord, in respect of this.
Re-inspect the portion which is padlocked is under the private respondent.
Private respondent.
The entire property is under ours.
You are the tenant, or how are you related?
I am a co-owner, my lord.
Co-owner. All right.
I am a co-owner. I have purchased the property, undivided property. They have filed one preemption case.
Let that be as it is.
We have to,
Injunction will not prevent the authority.
Well,
we
please
have to
come.
re-inspect, my lord, in respect of the site
the
where they are,
council come.
as
Let
your
the
lordship,
council come.
as your lordship, please.
They are
Report
continuous.
filed by the district engineer.
No.
CES Limited, district engineer, Howrah district, CES Limited, signed on 20th November 2024 is taken on record. It appears that the inspection could not be conducted properly as free access was not provided to the men and agents of the CES Limited. Stop paragraph. A report by the Shibpur police station signed on 2nd December 2024 by the officer in charge Shibpur police station is also taken on record. Stop next. An accommodation has been sought for on behalf of the learned counsel representing the private respondent. Stop. On such prayer, list the matter on 21st of January.
I'm grateful.
Okay.
My lord, my application, my lord, this is an order, this is a writ petition, my lord, that has been filed against being aggrieved by an order or a communication that has been passed by the learned district magistrate. Well, I'll just give you a very short background. Under section 14 of the SARFAESI Act.
What is your prayer? Tell me.
Now, my prayer is this honorable court has already passed an order upon the district magistrate to pass the order. District magistrate passed that order. That section 14 order was challenged before Death Recovery Tribunal. Death Recovery Tribunal upheld that order. Now, the simple thing is that order needs to be executed. Now, the district magistrate has again, in spite of DRT upholding the order, has again revisited his own order upon an application or on some information been given by the borrower, which under the law he's not been able to do, he's not permitted to do, because once he passes the order, he becomes functus officio, he just need to execute the order. And when DRT has already upheld, in spite of continuous follow-up with the district magistrate is not executing the order, neither the commissioner of police, whom the district magistrate has already appointed to execute the order.
Show me the order on review.
Order of review. Yes, my lord.
My lord, may I make one humble submission?
My lord,
Who are you for?
I am for respondent number 5 and 6, the private respondent, my lord.
All right.
My lord,
Who is for the state? Service.
My lord, service, affidavit of service. This matter was earlier also taken up.
Did anybody appear?
Lord, Mr. Kaur was appearing for the...
My lord, in this matter, my
I
lord,
do not see anybody's appearance recorded.
No, my lord, it doesn't record, but affidavit of service, my lord. Because these are very old.
I have got the copy, my lord. I don't dispute the affidavit of service. My lord, in this matter, I'm led by my lord, Mr. Joydeep Kaur, learned senior advocate. My lord, I have no instructions to proceed in this front.
My lord, may I just say this thing?
Accommodate
He
me.
is a senior advocate. He is not going to give you instruction. You will obtain instruction from your client.
My lord, I have taken instructions from the client, my lord.
Yes.
My lord, if your lordship is pleased to adjourn this matter for some time, my lord.
My lord, may I say
in
this?
that event, Mr. Kaur can address your lordship on this issue, my lord.
My lord, may I just say this thing? My main grievance is against the state authorities. Private respondent.
But the state is required to be put on
Exactly, my lord.
notice.
The state is not just, my lord, wanted to see the communication, which is at page 199. This communication is completely against the...
Please come. None represents the state despite service. Stop. Affidavit of service is taken on record. Stop. An accommodation has been sought for by the learned advocate representing the private respondents. Stop. List the matter on 28th of January 28. Let further notice be served upon the learned advocate representing the state respondents. Stop. Which page you say?
My lord, 199.
199.
That is, I am aggrieved with, and 207. Because Commissioner of Police is saying that please keep the possession on hold. What authority does he have?
The petitioner seeks implementation of the order passed by the district magistrate.
Which is at page, my lord, 185.
185. अच्छा, dated लिखे दिन तो 9th September 2021. Upheld by the
Debts Recovery
Learned
Tribunal.
Debts Recovery Tribunal.
Vintage order, my lord, dated 187 at page 6 September
Dated-
2023.
Dated 6th September 2023. Passed in SA
Yes, my lord.
03/2016, IA 1982/2021. Stop. Next. Learned advocate for the state shall come ready with proper instruction on the adjourned date.
I'm so grateful.
Grateful, my lord.
I am for the petitioner, my lord.
For the private respondents, ma'am.
On last occasion, your lordship pleased to pass a direction upon the WBSCDCL authorities concerned to make an inspection and
Was the inspection conducted?
Lordship, there was a dispute between the petitioner and the private respondent as to way leave collection. Now the private respondent came up with an idea that there is an alternative route which is available. On the first occasion, we conducted an inspection and apparently there was an alternative route. After my lord's order, we conducted another inspection. Now, in that inspection, lordship, two problems arose. My lord will kindly peruse. This is the letter which was served to both the parties, lordship. I'm just giving to my lord for my lord's perusal. Point number A, lordship, there is a problem regarding erection of pole number 2. Now, 3 poles request to be erected in that alternative route to supply electricity to Mr. Somucharan Golo, who is the petitioner. Now, lordship will kindly see is point number A. Due to narrow passage, the proposed pole number 2 cannot be erected to its proposed location. And also the proposed position where the pole will be erected is partially wetland, puddle, where pole erection is difficult. That is number one problem which we faced. And secondly, lordship, the line will be drawn over the land of one Gautam Kole. Gautam Kole is not a party in this petition, but line will be drawn on his land, and he also raised objection and did not allow us to draw the line. So we have come to this conclusion after this report, lordship, that this alternative route is not feasible. And even even the petitioner also is not willing to take the line from the alternative route. His suggestion is that there is a common passage from which the line needs to be drawn, for which one pole is required, but the private respondents are objecting. This is the present status.
So let the DM take a decision in the matter as to what is to be done. What is your submission?
My lord, I'm led by Mr. Kunal Ganguly in this matter, my lord. I'm praying for an accommodation for once.
Please come. Peruse the report filed by the station manager, Begumpur CCC, WBSCDCL, dated 4th of December 2024. Stop. It appears therefrom that a spot inspection was conducted to find out an alternative way for effecting electric supply connection to the petitioner. Stop. Paragraph. It was found that providing electricity connection through the alternate way as proposed is not feasible. Stop. Paragraph. The private respondents raise objection with regard to the drawing of lines through the alleged common passage. Stop. Paragraph. In such a situation, the court is constrained to direct the district magistrate, Hooghly, to
that is below respondent number 3. I have made a party.
Ascertain an alternative way from where electricity line can be drawn for providing electricity connection to the petitioner. Stop. Paragraph. A decision shall be taken in the matter by the district magistrate Hooghly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order, after giving the petitioner, the private respondent, and all other necessary parties an opportunity of hearing. Stop. A reasoned order shall be passed and communicated to all the parties. Disposed.
My lord, my one humble submission, my lord. My lord, that is the common passage which I have proposed. My lord, private respondent have already took their line, and my lord, they are already took their water line, my lord. That is, I have annexed here to, that is page number 48.
আচ্ছা যেখানে বললাম না যে প্রাইভেট রেসপন্ডেন্ট ইজ এনজয়িং ইলেকট্রিসিটি,
That is the common passage, my lord.
কমন প্যাসেজ যেখানে বললাম, কি বললাম?
The private respondents raised objection with regard to the drawing of lines to the alleged common passage.
তারপরে একটা বলেছে,
In such a situation, the court is constrained to direct the district magistrate HON'BLE to ascertain an alternative way where electricity line can be drawn by providing electricity connection to the field.
না যেখানে কমন প্যাসেজটা বলেছি ওইখানেতেই আপনি অ্যাড করবেন from where the private respondents are enjoying electricity connection, electricity and water connection. Yes. What is your name?
My lord, ma'am, I'm Kaustav Banerjee.
Record his name. Next.
I'm grateful. Apni?
80.
I'm for the CES.
I'm one for the petitioner, lady.
For the?
I'm for the petitioner.
Yes.
My lord, I am a flat owner. I purchased the flat from the promoter who developed the property by the property of the private sector. My lord, in my at the time of repairing of my flat, my lord, the private respondent disturbed. I filed civil suit. Injunction was passed. Thereafter, my lord, I wanted electricity.
What you want? Tell me.
That is, my lord, your lordship kindly comes to page 66. Earlier read petition. My lord, order was passed by his lordship the Honorable Justice Sabyasachi Bhattacharya, my lord. That is para number 5, my lord. Page 66. Lordship, kindly come.
Yes.
Learned counsel appearing for the CSC Limited contains that CSC Limited could not hold an inspection for the purpose of ascertaining feasibility of giving such connection. However, CSC Limited is agreeable on a principle to give a loop metered connection to the petitioner from the existing meter board position. And thereafter, direction was for a police help, but subsequently, CSC Limited changed their stand. They have last notice, my lord, page 85, my lord. They have given, I communicated the order, letter was issued, then I communicated the letter. There were several correspondences. That is page 85, my lord. I am reading from second paragraph. You are aware that existing meter board position of the premises was in damaged and dilapidated condition. Pictures of the same are enclosed. Therefore, to thwart the further untoward incident, we disconnect the entire supply of the premises on 26th February 2024 during the inspection. On 9th April 2024, the meter board room was found in same condition. You are unable to identify new position jointly for shifting the existing service. Thus, we reiterate our earlier stand stated in the letter such and such and requested you to kindly construct a new meter board room in consultation with other inmates of the premises in order to get new meter supply in your favor. By endorsing a copy of this letter, we are requesting Mr. Ajoy Kumar Das, Sri Chandrasekhar Das. These are the private respondents. So now I cannot construct any meter board due to obstruction and resistance from the private respondent.
Are the private respondents enjoying electricity?
No,
It has been disconnected.
No, they are not. They are not residing in the said premises, my lord.
You are a flat owner.
Yes, my lord. I have purchased.
And the private respondents are also flat owners.
They are the owner. They are the owner of the property.
Whatever. Now you are also a owner.
Yes.
Because you purchased a flat.
Proportionate.
My lord, firstly, this building is under construction.
Still under construction.
Still under construction. Now, my lord, we have held the inspection. We find that the meter board room is completely dilapidated because I have the picture also, my lord, as your lordship may see. So they have to basically identify a new part where we can shift the existing meter board, and some area has to be identified by them.
Temporarily, at least for
Temporarily
giving
also, in
connection.
case they need a electricity connection, they have to identify. We have to hold a fresh inspection, ascertain the feasibility, and then only we can do that. There were other two connections in the same building of two other persons. The
Which
private
you have
response-
disconnected.
we have also, for safety reasons, disconnected. So they have to, there is a feud between all these parties. They have to sort it out amongst
Can you not
themselves.
find out a suitable position for
We cannot,
fixing?
because the entire building is under construction, and unless they give us a suitable, they locate us at least, they show us somewhere, it is very difficult, and we have to hold a fresh inspection for the purpose.
That is all right. But then, see, the petitioner and the private respondents are in such relationship that nobody is going to show a common place for fixing or installing the meter board. Right.
That is also not allowing, they are creating hindrance also when we are.
Yes, they will.
Madam, what happened in this case? The promoters, there is two persons. One of them have that development. Building is totally, the old building is dilapidated, there is no existence. This building is totally under construction. Who will develop?
Well, who will develop is a different thing, but for time being, the petitioner is required to be provided electricity connection.
In a under construction building, how they have purchased? Is it the law? They cannot purchase. Is under construction.
Are they?
There is a CC. There is question of CC doesn't allow because the building is not constructed. So that is whether that flat is habitable or not, that will be given by the municipality. Otherwise, how they will enjoy.
Is the petitioner staying over there?
Civil court passed order for repairing of the flat, and I have repaired the flat. I am residing there. I have no alternative accommodation, my lord.
There is 7 except that
this
is
is
the
not
flat under construction. No flat is there.
Suppose some accident or untoward incident happens over there when you are staying, then what is going to happen?
No, my lord. New meter board should be allowed to be constructed.
Where to construct?
There are so many spaces.
So many spaces.
Construct, my lord. They have to construct the new meter board.
You construct the meter board and
we will give the electricity.
We can construct the meter board, but the private respondent.
Deviating the sanction plan.
Room has to be constructed.
Can they construct a meter room?
We are, my lord, the petitioner is residing with a family, my lord.
How can the petitioner reside in a place which does not have a sanction plan, which does not have a completion certificate?
Civil court has passed order. Your lordship.
I am not concerned with the civil court's order. Show me your sanction plan, your CC and everything. How you are residing there? Under which provision of law are you residing in an under construction building?
No, Lord, I have purchased the flat and
you may have purchased, but let the flat be constructed properly. Then only you can.
They will not.
Then there is a problem. It's the same photograph.
Yes, this is the dispute between promoter and the.
I do not know.
Either they construct or they repair the meter room.
Please come.
No, that is their problem, because we can.
Kindly allow to.
The petitioner seeks new electricity connection. Stop. It appears that the petitioner approached this court on an earlier occasion by filing writ petition being WPA 29082 of 2023, page 65. And the court was pleased to pass order on 18th January 2024, directing CAC Limited to provide to hold inspection upon prior notice to the parties to ascertain feasibility of given electricity connection. Stop. Paragraph. It has been brought to the notice of the court that an inspection was conducted.
9/4/2024.
And the report of the district engineer, Howrah district, is annexed to the writ petition. Stop. Paragraph. The inspection report clearly mentions that the electricity connection cannot be provided till a meter board room is constructed, from where the constructed over which the new meter may be installed for providing electricity connection. Stop paragraph. As on date, now photographs have been produced
they are
before
agreed
this
to
court
give limited
by the learned advocate representing the
My lord.
CESC Limited and the private respondent in support of the submission that the construction that the place where the petitioner is occupying is a flat which is under construction. Stop. The completion certificate is yet to be issued by the competent authority.
My possession letter was
Stop.
given,
Next.
my lord.
Possession letter has nothing to do with the completion certificate.
But I am residing there. I have no alternative accommodation, my lord.
The completion certificate is yet to be issued. Stop paragraph. In such a position, comma, it may not be proper for CESC Limited. Now, it may not be possible for CESC Limited to provide electricity connection till a proper meter room with a meter board is constructed by the applicant. Stop paragraph. The writ petition stands disposed of.
No, my lord, kindly allow police help, my lord. I shall kindly allow police help, my lord. Lordship, otherwise they will not allow me. Lordship, kindly allow me police help, lord. I shall construct the meter board. Lordship, kindly. My lord, suffering for long, my lord. I have filed the writ petition earlier.
Call the next matter, please.
My lord, kindly allow me police help, my lord. I have a prayer, my lord.
My lord, I am hearing for the license.
For the petitioner here, my lord, regarding my lord, I am challenging the provisional order as provisional assessment order in respect of the, my lord, unauthorized electricity used. My lord,
But there is an appellate forum. Why are you here? Against the provisional order, you can prefer an appeal.
Provisional order, my lord, without hearing my natural justice violation.
Appeal, there is a provision
Natural
for
justice,
appeal.
no, my lord. Natural 126 subsection 3, specially categorically said that the hearing was there.
My lord, here, final hearing held on
Conducted.
Yes, my lord,
Let
in
me see.
presence of
Presence of the
Yes, my
petitioner.
lord. This is my lord.
Your client is not giving you proper instruction.
Annex this all document.
And final
Annex this all document.
and final bill was raised, my
My
lord.
lord,
at same-
excessive amount, my lord, domestic house, my lord, excessive amount, my lord, provisional amount.
Please come.
Kindly see.
The petitioner is aggrieved by the provisional assessment order.
Without hearing.
Dated 16th August 2024.
Subsection 3, 126
which
subsection 3, my lord.
was allegedly issued without hearing the petitioner. Stop paragraph. Learned advocate representing WB SEDCL submits upon instruction that the final assessment order has also been passed upon hearing the petitioner.
Kindly see this upon hearing.
Who was present
on that date,
at the time of hearing.
Kindly see.
And his signature is recorded on 10th of September 2024. Stop paragraph.
In this respect, my lord, final order liberty be given. Final order can
Will
be
be open
challenged.
for the petitioner to take steps in accordance with law if he is aggrieved by the order of final assessment that has been passed. The writ petition disposed of, stands disposed of. Instruction to be taken on record. WBSEDCL instruction.
I am producing this. I am for you may submit the report.
Yes.
My lord. Kindly see. আরে এখানে আছে তো লোক না গেল
Yes.
Yes.
I am for the petitioner, my lord. Kindly see, there is a order. Electric line has been disconnected and the final order has been passed.
For providing
my
unauthorized connection.
আমাকে বলতে না আবার সুযোগ
Yes,
আছে।
yes, final order.
My lord, I want to pay that amount, line be restored. That is my only prayer.
49,700.
I'll pay.
A final order of assessment has been passed by CSC or what? CSC Limited on 27th of June 2024, disclosing the amount which the petitioner is liable to pay for obtaining reconnection. Stop. Paragraph. Learned advocate representing the petitioner submits upon instruction that his client is ready and agreeable to pay the amount mentioned in the final order of assessment. Stop. It has been prayed that the electricity line may be directed to be reconnected upon payment of the due amount. Stop. Paragraph. The instant writ petition is disposed of by giving liberty to the petitioner to pay the amount.
Amount
as
mentioned, my lord.
That amount is in page 13 of my report.
13 of your report.
Sorry. It is 49,769.
That amount
plus 4,927. Page 13, my lord. The last annex.
It's page 15 of the writ petition. It's the same thing. It is the same thing. কি বললাম?
49,769.
That amount be mentioned, I'll pay.
Amount of rupees 49,635,68 and the government duty of rupees 4,927.50.
My lord, according to my instruction, my lord, the amount has increased a little bit, my lord. If your lordship kindly takes up my report, my lord, page 13, my lord.
Well, lord,
Yes,
that
yes.
amount I
Increased a little bit, my lord.
823.
49,769.80 and 4927.
4927 বললাম না?
First, second,
4927?
fourth paragraph.
No, wait.
Page 13, fourth paragraph.
After the total electricity charge payable to the comes to rupees. What is 8273? Next paragraph. What is this?
কি জব যাতা বলছি
যাতা কেন বলতে যাবো? My lord, this amount is the government duty.
So he has to give that also.
My lord, round off.
আচ্ছা কি বললাম?
আমি আমার বাড়ির বাজারে হিসেব দিচ্ছি না।
And the government duty as indicated in the figure ta likhben na, as indicated in the final order of assessment dated 27th of June 2024.
Great.
Stop. Within a period of
upon payment
1 week of payment of the due amount, comma, the electricity line shall be reconnected by CESC Limited.
My lord,
Disposed.
deeply.
To be reconnected within 1 week.
But I for the state respondents, my lord, in compliance of a lordship's last order, my lord, the ADM and DLR is personally present before lordship virtually, my lord.
My lord, Mr. Sengupta, led by Mr. Lahiri, appearing for
Which
petitioner.
Ken Gupta and which Lahiri? I do not know. There are so many.
And Mr. Orkodipto Sengupta, led by
Yes.
Mr. Anandu Lahiri, they are appearing for the
Yes.
petitioners, my lord. But they are not available today, my lord.
They are not available.
They are not available, my lord. They have
You make submission because the EDM or whoever somebody is present online.
My lord.
What is the position now? Has the has the classification of land been made?
Honorable Madam, myself.
Please sit down. Yes.
Myself, Devavati Indra, District Land and Land Reforms Officer, Malda, Madam. Madam, my humble submission is that, ma'am, case number 83, 84, and 95, these three cases are analogous, and I have been directed to appear virtually. Ma'am, in compliance of Honorable Court order, we have started demarcation procedure, ma'am. Your Honor, Madam, we have already completed 685 acre of land, acre of demarcation out of 700 acre approximately. Ma'am, it's a huge area, ma'am, but we will be completing, we will be able to complete the entire physical demarcation process within 1 month. Ma'am, this is my humble submission. If Your Honor, ma'am, court allow us 1 more month's time. Your Honor, ma'am, one more submission that the Honorable Court has directed us to complete the process with the help of Science and Technology Department for geo mapping. Ma'am, we are also keeping close liaison with the department so that it can be completed within 1 month, ma'am. Ma'am, one more submission, ma'am. Ma'am, we have NGT National Green Tribunal case, ma'am, on 23rd. Hearing is pending on 23rd. We are also looking for that, ma'am, for the order of the Honorable Court, ma'am.
23rd of which month?
And 23rd January, ma'am.
Oh, that's just a holiday.
No, maybe the tribunal is central, so it may be open. Have you followed the case of the petitioner that they say that their land is classified as Itkhola or something, Bastu, but then you find on physical inspection that it is a water body.
Your Honor, ma'am, yes, ma'am.
So the records are to be corrected accordingly.
Ma'am, the area is actually 5 mojas are there, ma'am, total. The total area is 700 acre. As per the Honorable Court's order, ma'am, we have constituted one committee, and on the basis of that committee, on suggestion of the committee, the conversion, especially conversion has an impact on environment directly, ma'am. So conversion has been stopped for all the 5 mojas. Ma'am, after demarcation, we will be able to take
Very
the
well. Please take down. An accommodation has been sought for by the learned counsel representing the petitioner. Stop. The District Land and Land Reforms Officer Malda is virtually present. Stop. It has been submitted that the process of identification of the water body is continuing and it will take at least 1 more month to conclude the said process. Stop. Paragraph. In view of such submission, let the writ petition appear in the list once again on 24th of February 2025. Stop. An updated report by the District Land and Land Reforms Officer, Malda, shall be placed before this court on the adjourned date. Stop. The virtual presence of the District Land and Land Reforms Officer Malda is dispensed with for the time being. Madam, if required, we will call you later on. But as of now, let the report be placed on record and then further action will be taken.
Followed, ma'am, Your Honor, ma'am.
Very well.
But instead of 24th, can it be after that? Because some person.
24th of February.
Instead of 24th of February.
You want
either prior to 20th of February or
after that.
First week of February,
No, she says 1 month's time will be required. Today we are on 15th, so at least till 15th I'll give time. I have kept 1 month of buffer zone and then it comes to the 24th. You want
week of March.
First week of March, 4th of March. 4th of March it is adjourned. Next matter is also same?
Same matter.
Very well. You are there?
No, I think Mr. Day is there, madam. Mr. Chandipuram.
Another matter, I think it's appearing item number 95.
Wait, we are in item number 83 now?
My lord, same identical, my lord.
Maybe 84. Let me see 84. 84, same order, none for the state. Yes, call 85. Record the appearance of the petitioners. Petitioner appearance, same. State name.
84 and 95.
85.
8-5 I appear for on behalf of the petitioner.
I am appearing on behalf of the insurance ombudsman.
On all earlier occasion, your lordship was pleased to direct the LIC to get the instruction whether retrospective deduction of annuity can be refunded. My lord, the case in the writ petition is this, my lord. We have invested 27 lakhs instead of 15 lakhs. The permissible limits is 15 lakhs. My lord, there is a non-disclosure on behalf of the petitioner, and they have retained the money for 3 years, and thereafter suddenly.
Yes, what is your
My lord,
instruction?
ombudsman is the mediator, and my lord. And my lord, as per statement of the petitioner and the LICI, the matter was disposed of. And my lord, there is some, your lordship kindly come to page order of insurance, page 41, my lord. My lord, Pradhan Mantri Bhaya Bandhana Yojana is the, my lord,
Can
government.
any relief be granted to the petitioner? Tell me.
My
I
lord,
do not want to go to any
my lord,
details.
in fact, insurance ombudsman has nothing to do. Then LIC, your lordship was pleased to direct.
But then
on
will you
last
not
occasion.
represent the LIC also?
No, no, my lord. In this matter, not.
In this matter, no.
In this
You-
matter, Mr. Dilip Kundu and
Yes, Mr. D.K. Kundu and Mr. A. Basu's name is there. Where are they? I'm passing it over. Please give a phone call to them. Take the number. She must be having it so that it can be taken up. I'm just passing it over.
mine.
The same 85
Same.
and 86 are same.
85, 86, same. All right. 87.
My lord, in item 87, my lord, I appear for the petitioner. My lord had passed an order dated 13th November 2024, whereas my lord has expressed my lord's mind that this matter needs to be heard in details and had directed the respondents to file the affidavit in opposition.
Who is appearing for the respondent?
My lord, Mr.
Respondent.
Pulokesh Bajpayee for the respondent number 6 and Mohit Gupta for respondent number 1 to 3.
Who answering respondent?
My lord, Mohit Gupta, Mr. Mr. Mohit Gupta, my lord. In
1,
this,
2, 3.
yes, my lord.
In this, where is he?
My lord, no opposition has been filed and we.
No opposition filed?
No, my lord. It was to be filed by 3rd December 2024.
Several disputed questions of facts involved. Are you aware of his phone number?
No, my lord.
Inquire, I can pass it over. Bring him over here.
I don't know his number.
None appears on behalf of the respondents.
Uh,
Stop. Paragraph. Let a notice be served upon the learned advocate representing the respondents, intimating that the matter will appear in the list on 28th to 8
Grateful, my lord. 28?
January.
28.
28 now.
My lord, I'm sorry, my lord, but my lord, would it be my lord's pleasure to direct them to file the affidavit opposition by the next date? We'll try to notify them by tomorrow itself. Because,
The direction was, there was no direction for
there
filing
was a
opposition.
direction.
There was a direction.
Filed on 3rd December.
All right.
That
Acha.
they have not complied.
Let the affidavit in opposition be prepared and circulated prior to the adjourned date.
Grateful, my lord. Grateful.
May it please your lordship, my lord. And I beg to appear on behalf of the petitioner. My lord, the state on the last occasion was directed to file an affidavit. Prior thereto, my lord.
Yes, state was directed to file
The
a
state was
report.
directed to file an affidavit and serve the same upon us, my lord, by the 6th of December 2024.
Not done.
But not done. Yesterday, I had a word with the learned advocate for the state. He said that the affidavit is ready, but we haven't served you. We will serve you once the matter is taken up.
Nobody
But I'll
here?
tell your lordship, my lord, what the difficulty is, my lord. I have been selected, my lord. I have been successful pursuant to my participation.
Where is Mr. Dinda? Mr. Dinda, you spoke to Mr. Dinda?
My lord.
Where is he?
Yes,
I am appearing on behalf of the respondent number 7 HPCL.
there was a direction for further service, my lord, upon the oil company. I am
Now the-
successful, my lord. I am a successful tenderer. The letter of intent has been issued. It is a time-bound, my lord, letter. The oil company had sought for, my lord, a no objection from the magistrate, the district magistrate. Now, my lord, my antecedent is, my lord, I belong to the party in opposition, my lord. I have been formerly, my lord, a councillor of the, my lord, Asansol Durgapur Municipal Corporation. At present, my wife is the councillor. There are political cases against me which are pending. Now, the clauses, my lord, in the contract, in the tender document, my lord, it speaks about, my lord, conviction, not pending cases, my lord. Now, my lord, they applied for, my lord, this particular no objection from the district magistrate. My lord will find it at page 203. This was issued to the district magistrate, food section.
January 24, we are
January 2024.
1 year has passed.
Till now, my lord, they have kept it in limbo, my lord. What they have done is, my lord, kindly turns overleaf, my lord, page 205.
Yes.
The district magistrate writes to the officer in charge,
Mhm.
NOC for MS HSG retail outlet at RS plot number such and such. The content I'll read out. Apropos the subject cited above, you are requested to verify the antecedents of Mr. Abhijit Acharya of such and such and intimate this office whether anything adverse is reported against his name in your police station.
Mhm.
Thereafter, my lord will find page 205A, my lord. This is the chart. These are the number of cases which are pending against me. In none of the cases, my lord, I have been convicted. In fact, my lord, there is a further development in two such cases, my lord. My lord, I have been acquitted now also. The others all are pending. Now, if my lord kindly takes pain to come to the, my lord, the letter of intent, which is at page 171, my lord will find the letter of intent which was issued in my favor. Now, my lord kindly takes pain to come to, my lord, clause 17 thereof, page 174.
Yes.
Clause 17, subclause D. The letter of intent will stand automatically withdrawn and cancelled on the happening of any of the following events. D is, in case you are found to be convicted for any criminal/economic offense involving moral turpitude. So it speaks about conviction, and same was, my lord, the stipulation in so far as, my lord, the tender conditions were also concerned. My lord will find it at page 104, my lord, which speaks again about this, my lord. Kindly turns, my lord, to page 104, my lord. I'll just read out the relevant portion. Page 104. Starts, my lord, a little above the middle part of the page. In addition, they should not have been convicted of any criminal offense involving moral turpitude/economic offense other than freedom struggle. So, my lord, this is the clause. Now, what, my lord, the state administration is doing, my lord, just because of my political antecedent, my lord. Now, my lord, I am being, my lord, right, my lord, they are trying to, my lord, disentitle me, my lord, from, my lord, my successful participation. Because the letter of intent is time bound. Because it is also stated, my lord, page 114, my lord will find.
What is the contract for?
My lord, it is for, my lord, a petrol pump, my lord.
All right.
They are deliberately keeping it pending.
Show me your letter of intent once.
My lord. My lord, kindly page 171.
171. All right, 1 minute. You require an NOC.
We require a NOC.
And the requirement is only for the purpose of ascertaining as to whether the applicant or the successful tenderer is convicted in any criminal or economic offense.
That is perhaps not the reason, my lord.
What is the other reason?
Other reason is, my lord, it's only the land which is been given, which is been offered
Yes.
by the petitioner, my lord. It's a method of cross-checking the land. There is no other reason.
Cross-checking the land?
The land records, because when they have participated, my lord, they have also produced the land records, my lord. which we have already authenticated.
Land records of the
Petitioner.
But the land that I
Where
have
the-
furnished, my lord.
Where the proposed petrol pump
Oh,
is
you
supposed to
have
set up.
furnished this land.
Yes, my lord. He is
This
a
is my-
independent bidder.
It is your land.
Yes,
You
yes, I'm
have
a successful bidder.
right, and for this purpose, you had to identify a land.
Yes, and they have now sought for the report from the district magistrate. My lord, kindly take, my lord, the letter is at page 203. Now, prior thereto, my lord, this was in January 2024. Prior thereto, my lord, kindly turns to page 202. The corporation, they say that the land appears, the land is lying in a vacant position. As per report, NOC for setting up MSHSD retail outlet may be started. But now the district magistrate, my lord, he is traveling, my lord.
Wait, I want to understand what is this NOC for? Is it only for inquiring the criminal antecedents of the applicant or for some other purpose?
2131.
203, yes.
203, my lord.
Hmm.
This is the letter, my lord, that the corporation issued to the
DM.
district magistrate. Kindly, if I may place the record, their document. We propose to set up a MSHSD retail outlet at the above mentioned location to meet the requirement of the petrol pump products for motorist, agricultural sector of the above mentioned location and its adjoining areas. We have issued letter of intent in favor of Abhijit Acharya. The details of the land as mentioned above. Kindly see the details of the land is being mentioned. This is for a reason that the land is being cross-checked from the government authorities as well. We are enclosing here with 6 copies of the drawings of the above mentioned location and 6 copies of the form 11 duly filled up and signed, copy of the LOI, copy of the land records and ID proof of LOI holder such and such. But there are instances that have come, my lord. There are false documents that have been produced. This is in a way of cross-checking with the land department that the documents produced are genuine in nature.
This is in connection with the status of the land that he has offered.
Status of the land where the proposed petrol pump is going to be set.
Right.
Uh-huh.
Apart from this, his personal criminal antecedents. This you also
My lord,
require.
clause says the tender condition says that if he's not been convicted, my lord, he's eligible.
Right.
He's eligible.
Now, the list of cases which has been shown just now at page 205
Yes.
cap say, he says he is yet to be convicted in any of the matters.
My lord.
So, and in 2 matters, he has already been acquitted. So that is one part.
But discharged in one and acquitted in the other one.
Very well. Now, 203 is the status of the land which
Yes.
you want to cross-check.
Extent is to the status of the land.
Right.
Not beyond. My lord, even if criminal proceedings are pending, my lord, as far as the land is concerned, it's a genuine land that's been offered. Documents are all in order, and he has given all the supporting documents. If they are in order, then we have based on that we have issued a letter of intent. But once we get a no objection certificate from them, my lord, then we'll issue the formal contract.
And your guidelines mentions about obtaining the NOC from the
But
DM?
there is another reason to it, because once the petrol pump has been set up based on the NOC, my lord, the petitioner has to obtain a fire license as well. They have to obtain an explosive license. These are series of licenses that you procure based on the NOC that is going to be provided to them. And then,
By the DM only?
no, DM will only grant the NOC. Based on that, they are going to apply.
The NOC has to be given by the DM and no other authority can issue this DM, NOC. And
They have the
the,
statutory authority. my lord.
and the NOC and the
My lord, fire, my lord, will find at page 200, my lord. They have
That is
already
all right.
certified.
There are other licenses to
Yes.
be
The
obtained.
DM is doing it, my lord, for oblique political motives, my lord.
Where is the state? Who, Mr. Dinda? Where is Mr. Dinda?
My lord, kindly appreciates their conduct, my lord. The day one when, my lord, the matter was
Listen,
admitted, my lord.
please get hold of the learned counsel and bring him
My
here.
lord, kindly keeps it at 2 o'clock, my lord.
Not 2 o'clock. I'm passing it over. If he comes prior to 2 also, I can take it up. Give a
kindly
phone
appreciates
call.
the-
By this
I'll
time,
do
he
that
could have been brought over here.
Dindaকে phone কর না।
89.
এখনই ডাকছি।
Here for the response number 3. I appear for the response number 3.
Respondent number?
3.
Who is the authority?
This is not State Urban Development Agency. But they had floated a tender that conditions of tender is under challenge. I appear for the respondent number 4.
4. And the petitioner is not here?
Petitioner, Lord, I don't find. In fact, the contract has already been awarded in November 2024.
None appears on behalf of the petitioners at the time of call. No accommodation sought. Dismiss for default.
Masuk.
Record the appearances of the respondents.
Appearance.
90,
90, my lord, for a moment, my lord.
So I beg to appear on behalf of the petitioner.
yes.
Affidavit in opposition. Lord, kindly have a look, the last order, my lord. No. The Lordship was pleased to serve the copy by 13 December.
My lord,
My lord,
there
they
was
served
a,
the copy 7 January. my lord.
my lord, there is a communication from the department to myself.
Which department?
My lord, the
Ministry of Corporate Affairs.
Ministry of Corporate Affairs.
the Minister of Corporate Affairs.
You were there?
Yes, man, I'm led by Mr. Nundi.
Yes.
My lord, there is a oral communication from the department that they want to, they have intended to engage ASG in this matter, my lord.
Yes.
And they have sought for the permission. My lord, the permission is awaited, my lord. Kindly keep it on next week or.
No, my lord, this is the.
Very well. It can be urgent, but in the meantime, what about the affidavit that has been served?
My lord, we have submitted our affidavit on behalf of the respondent number
Lordship,
1 and 2.
there was a,
File reply if they show wishes, otherwise.
Lordship, there was a direction by filing affidavit 13 December. They served the copy 7 January, my lord. My lord, affidavit is on, my part is ready. My lord, I am paying 1 day adjournment, keep the matter on Friday, my lord, kindly. I have an urgency, my lord, I have challenged the lookout circular notice, my lord. That is the totally bad in law.
Please come. Affidavit in opposition on behalf of the respondent numbers 1 and 2 filed in court today is taken on record. Stop paragraph. Learned advocate representing the petitioner seeks time to file reply to the same. Stop. Let reply be filed by
Reply is ready, my lord. Both to be taken
Not yet.
after 2 or 3 p.m. yeah. I will serve the copy today itself.
by 17th January. Stop. List on 24th of January.
Grateful.
Lord, I have 91, I am appearing for the petition. I have advised my client, my lord, to withdraw and move the appropriate forum, that is in the pending partition suit. Kindly bear with me. I have not received the instruction. I kindly keep it in February. It will be withdrawn. Kindly keep it in February.
Wait, my lord, it's not maintainable in any event.
I am aware of that. I have.
Learned advocate representing the petitioner seeks adjournment of the matter till February. Stop. In view of such submission, list on 12th of February.
Kindly list it after 20th of February. They are moving the lower court. There's a pending suit. After
There is no point keeping a writ petition pending because they want to move it lower court. They might as well withdraw it.
Kindly bear with me. I'll come back. I'll withdraw it. I'm saying.
This is a chance
Oh,
litigation.
but then keeping it pending over here and obtaining orders from the court below will be something different.
I will not. I'll first withdraw it and then they already filed an application. Kindly keep it very well. Keep it on 12th of February. Very well. I'll come.
Let it appear on 12th.
Very
great.
Mr. Kundu has come.
Please wait. Yes.
Passover matter.
Yes, 92. Nobody is there. Acha, theek hai, call the Passover matters.
85 and 86. Well, Mr. Kundu is.
I'm sorry, my lord, I am not following.
85.
My lord, on the last occasion, your lordship was pleased to direct the LIC that at what rate of interest they have to pay. My lord, according to my instruction, my lord, we have already paid interest at the rate of 6.25% over the amount, my lord.
Not for the whole period, possibly, or not for the whole amount. It's only a portion of it.
The
My lord,
permissible
may
limit.
I-
They have
Yes.
paid the.
On submission, my lord, let me file a short affidavit, my lord, stating the amount, details of the amount, how it was paid.
That has been given in paragraph page 6 of the
My
writ
lord, that
petition.
is their case, my lord.
No,
My lord, let an affidavit be filed on
that's
behalf
the
of
just
LIC, my lord.
replica of the ombudsman report, my lord.
the judgment.
You cannot improve much in the affidavit. The court was just wondering on the last occasion as to whether anything else can be paid to the petitioner for you withholding the amount, the
Correct.
excess amount.
I'm grateful.
Nothing more.
My lord, according to my client's instruction, my lord, we have already paid interest at the rate of 6.25%.
For the permissible limit, you are holding some extra money also.
Yes, my lord, on that also.
For
My
3 years.
kindly allow me to file a short affidavit, my lord, so that the matter would be finalized.
Unnecessary
Resolved.
dragging the issue.
No question of dragging.
Josh Sahib শুনতে
According to
চাইছেন।
my lord, give me one chance to file an affidavit.
A report on in form of affidavit.
Please come. Learned advocate representing LICI seeks time to file an affidavit in the matter. Stop. Let a report by way of affidavit be prepared by LICI disclosing as to whether interest can be paid to the petitioner on the excess amount that was deposited and held by the authority for 3 years.
3 years.
For 3 years.
My lord, affidavit on
Such
the form
report
of
shall
report.
be
Yes.
report report in the form of affidavit shall be prepared and circulated by
Report cannot be.
29th of January. List the matter on 12th of February.
My lord,
Exception to the report
My
will
lord.
be filed prior to the adjourned date.
a proper affidavit should be filed.
No, the court is not inclined to give you that much of time and that much of liberty.
No, my lord, within by that time.
No, because the other issues are not disputed. It is only one issue that is disputed. You dwell upon that, finish it off. Same order in the next matter, 86.
I'm grateful to you.
85 and 86 is same order.
My lord, item 88, my lord. My lord, I
Yes.
went out and I called Mr. Dinda immediately.
Yeah.
With regard to that matter, my lord, I've just
My lord.
taken instruction, my lord. My lord, the NOC is generally been issued in the favor of HPCL. It has not to do anything with the petitioner.
Yes.
HPCL as an authority is obtaining a NOC that we are setting up a petrol pump in that premises.
Do you have any objection or not?
And the NOC will be issued only in favor of HPCL.
What steps are you taking to obtain the NOC?
We write to them
And then,
and then they issue the procedure. is-
suppose they do not issue or they keep the matter pending, then what happens?
Reminding letter to them. Other than that, because they are. the
You do not have anything to do.
They-
Now the petitioner, who is a successful tenderer or bidder, has approached for the NOC. What is your submission?
My lordship, he is trying to connect, but he is not able to connect. I'm submitting the opposition. My
The
lordship, what is
opposition, my lord, there was a direction.
What is the stand of the state?
My lordship, I don't have idea. He's trying to connect, and I'm just.
These are all strategies, my lord, to but not deprive me, my lord, from the fruits of my
I'm
success.
giving
in
this
the- in the-
opposition, ma'am.
Copy to HPCL also, because it is they in whose favor the NOC is required to be
I'm asking, my
issued.
lordship,
My lord,
I'm
9th of December, this was affirmed. The direction was to serve it by the 6th of December, advance copy. My lord, kindly appreciates the conduct of the state. It is, my lord, filed on the 9th of December, the date of affirmation. This is the conduct.
Acha, affidavit in the form of report in the form of affidavit. By the district magistrate, Paschim Bardhaman, affirmed out of time, is taken on record. Stop. A copy of the same
My lord,
has been
kindly takes
handed
para
over
4, my lord. The reply, answer is there.
the learned advocate representing the petitioner in court today, not yet served on you. Stop. The copy is yet to be served upon the learned advocate.
Well-
Oh, not the upon the petitioner and the and HPCL. Paragraph 4.
Paragraph 4, the last 3 lines.
Yes.
As on date, though the verification reports received from other authorities are found to be in order, however, the police authority, when being approached, was not found satisfactory.
What does this line mean?
they are
Police
referring to my lord,
authority,
the list of cases.
when being approached was not found satisfactory. I do not understand the meaning of this line.
No, my lord, the HPCL has clarified adequately, my lord, what is the purpose for issuance of the no objection. This pertains to the land. This is an admission that everything is in order.
List the matter on 22nd of January.
But 22nd?
Yes.
Maybe on the 21st, my lord.
I'll get 21st. 21st. Yes. Do you intend to file an
I
exception?
don't see, but this is an admission because everything is in order.
The parties shall come ready.
I know we stay in a police state,
With,
my lord, but the police
hearing.
cannot regulate the grant of tenders also now.
Next.
Grateful to your lordship.
আর কোনো পাসওয়ার্ড আছে কি?
Under item number 100, Mr. Banerjee is here. Mr. Banerjee is appearing on behalf of the
Petitioner, madam.
petitioner. I am for the respondent.
That matter, madam, that DM was
Red Cross matter, Lord.
Red Cross matter, DM.
Indian Red Cross Society, Aura District Branch matter.
That bypassing the DM, they have made a body that was challenged before this honorable court. The DM has made a file and report. But I'm ready with the reply also. I'm handing over to it. Let it be fixed any date.
Kindly fix the date because Lordship, they have operating the bank account.
No, I have
Lordship has passed earlier, passed it.
in terms of your lordship order, we are
eligible. That is the question to be.
I am not eligible. DM is eligible. My lord has directed the DM to
Item 100.
100.
Combined list.
Combined.
It will be taken up. আজকে দুটো থেকে কি
My
অন্য কিছু নেবে?
My
আজকে
lord.
দুপুরবেলা
Item number 4 and 5 today fixed for release. I am the respondent of 5. So, I did not appear because the matter was fixed for release. But your lordship have passed order, which greatly affected me. They have wrongly submitted that they are the account operator, but I am the account operator.
Why did you not come at the time of taking up the matter?
It's my fault. I'm admit. But
If it is your fault, file
no,
application.
my lord,
This matter, my lord, I have today missed the brief, but the affidavit is already ready, and as I have been instructed, the affidavit has already been served upon the petitioner. And,
You don't have a copy now?
oh, my lord, I have missed the brief today.
Dismiss for default. Record appearance of the state.
My lord, I am appearing for the respondent number 5.
My lord, I appear for the petitioner. My lord, a person who was given work order in the year 2014 for a period of 3 years eventually went on to work for 10 years, simpliciter on extension. And my lord, when the pressure mounted on the authority, fresh auction tender was called, and again the same person was favored with the work order at the cost of persons like the petitioner who has the best credential. But the matter relates to tender for supply of manpower for housekeeping work at Midnapur Medical College. Malad, the ground for which the petitioner was rejected at the technical stage, Malad, was utterly flimsy and non-ex. Malad, they say that the essential
Private respondents,
Malad,
3, 4, and 5.
Malad, 5 is the private respondent, 3 and 4 is the hospital authority. Malad,
Who are you
I am for
representing?
respondent number 5, my lord.
Malad, the state usually represent the hospital. Malad, on the last occasion, Mr. Bishwabrutu Basu Mollik appeared.
Yes, I see.
Malad, there was a direction upon me to serve the hospital, a notice upon the hospital authorities. Malad, I have affected the service.
All right.
Malad, my case is a bid which was not substantially responsive in terms of the NIT eventually succeeded. And a person who has all the credential was deprived because the authorities have closed their eyes on a document which apparently shows that I have the sufficient experience. Malad, the essential criteria, Malad, the qualification for participating in the tender bid is a person must have supplied minimum Malad, 60 manpower to a single health facility having 300 beds. Malad, this is the requirement. Malad, they say while rejecting my tender that I did not have sufficient experience in a single health facility. Whereas my credential, which is enclosed with the tender document, shows that I have got 4 different health facility. And the maximum number I have served is 704. I'll show it from the document. This document was...
And this work order right now, which is subsisting.
It is in favor of respondent number 5.
Right. For what period?
3 years.
Starting from?
That's subject to correction. It is 5th of August 2024, which is the award of contract.
Oh, 4, 5, 6, 7. So it's still some time.
My
Tell me, did you bring this to the notice of the authorities?
I did, my lord, in
Please show.
July. My lord, kindly take my representation annexure P4, page 172. My lord, which is that volume number?
Yes.
Which is that volume number?
It is a letter.
It's a letter, my lord, 23rd of
July.
July. My lord, may I place it before your lordships?
No, you do not have to place the letter. Has any steps been taken?
Nothing, my lord. This is followed up by another letter on 25th of July. They chose to ignore.
Anybody representing the MSVP of the medical college?
That state usually appears for them.
And then the hospital usually is a state hospital. You represent the hospital also?
Well, state usually represent.
Where is he? Who is Shayok Chakraborty? Who is assisting Mr. Basu in this matter? He doesn't come to court. And the matter is over here. Please come. What is your stand? Please.
The allegations made against the respondent number 5 is not at all correct, my lord. I will show, my lord, to your lordship 2 pages. My lord, page number 175.
My learned friend is going into the merit. If I may then place my case.
And selected as LI depending upon the highest credibility as per GO number 2320 dated 7th June 2022. in the meeting resolution dated 5th August.
What is the name of your client?
Chandan Sengupta, my lord. Page number
Chandan
175.
Sengupta, 174,
Five.
serial number 4.
Yes, my lord. He was not
Elected as L1 and
financial
petitioner
bid
is?
also. We could not.
How could I?
Then, my lord,
Petitioner is, wait 1 minute, Nawal Kishore Singh.
Well,
What is your position in the
I was rejected at the technical threshold.
technical bid
Technical bid,
stage?
Let me place the document. They are saying a particular document is not on record. And on the contrary, they have not, they don't have the credential. But the authorities could dig down and find all the credential for him.
my lord, 182. In the financial bid also they could not. My lord, kindly say
How can I,
page
man?
He
182.
couldn't participate in the
They have
financial
illegally
bid at
rejected
all
me.
because he was out in the technical bid. Please come. The matter relates to a tender floated by the Midnapur Medical College and Hospital. Show me the tender, please.
Well, the tender is at page number 23.
23. For cleaning and scavenging / housekeeping services in the medical college. Stop. The petitioner and the private respondent both participated in the tender process. Stop. Allegation of the petitioner is that the respondent authority illegally and arbitrarily rejected the bid of the petitioner at the technical stage by ignoring the documents which were already on record. Paragraph. Specific contention of the petitioner is that the private respondent does not have the credentials to participate in the tender process.
Well, my submission is his bid was not substantially responsive.
Far less being awarded the contract. Stop. The bid was
Not substantially responsive. The relevant document, the pro forma statement, was not in the conformity with the tender document. This is my submission.
the documents submitted by the private respondent was not in conformity with the terms and conditions of the tender.
My lords.
Paragraph. An objection was raised by the petitioner on 23rd July 2024. But the same is yet to be considered. Tell me one thing.
My lords.
When was the bid opened?
Well, the bid was opened on, financial bid was opened on 30th of July.
Technical bid?
Well, technical bid 23rd of July. My correspondence is simultaneous to the issuance
On the
of
same date. All right. And you filed the writ petition.
I filed on 3rd of October because I was following up with the authority. They were giving me this hope that my case will be considered.
Will that extend the period of limitation? At this stage, can they be directed to consider?
Well, may I make one submission?
Actually, okay.
Well, if the person.
1 minute. কি বললাম? Far less be awarded a tender, তাই তো? Right. Learned advocate representing the private respondent denies the allegation of the petitioner. Stop. It has been submitted that the offer of the private respondent was accepted only after verification of all credentials submitted by him. Stop. Paragraph. None represents the hospital authority. Your affidavit of service is taken on record.
There are two affidavit of service, one the initial and subsequent order.
Yes. Two affidavit of service taken on record. আচ্ছা এবার আপনি লিখুন যে it appears that the tender has now the contract has already been awarded in favor of the private respondent, and the same is valid till October 2027. Stop. Paragraph. The whether the the court is not entering into the merit of the allegation raised by the petitioner at this stage, as the tendering authority is competent to deal with the allegations raised by the petitioner. Stop. Paragraph. The instant writ petition is disposed of by directing the MSVP.
My lord, may I make one submission? My lord, a person cannot be judge of his own cause. My allegations are directed against the MSVP, my lord, any higher official of the state, fine, my lord, health department. This is my prayer, my lord. Inquiry be made by a higher official. The allegation concerns the MSVP.
Let the principal in that case consider.
My lords, my lords.
আচ্ছা একটা কি বললাম এখানে স্টপ, তারপরটা কাটুন। এমএসপিপি বললাম তো, ওটা লিখুন। as the allegations of the petitioner are primarily against the respondent number 4, being the medical superintendent cum vice principal of the medical college. Accordingly, the court thinks it fit to direct the principal of the said medical college to consider the grievance of the petitioner and verify as to whether the respondent number 5 possess the credentials for being awarded the contract. Stop. An opportunity of hearing may be allowed to the petitioner and the private respondent prior to taking a final decision in the matter. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If the allegations of the petitioner are found to be proper, then necessary remedial steps shall be taken by the principal of the college. Disposed.
So grateful, my lord.
My lord, I beg to appear for the petitioner, my lord. My lord, is that matter, my lord, where the information sought for by the petitioner in his RTI application was not supplied, my lord. Now, pursuant to the order of this honorable court, your lordship's order has been partly complied. I would like to bring your lordship's attention to page 15, my lord, the RTI.
Yes.
My lord, the college authority has only provided me the rank-wise merit list recommended / finalized by the board of experts, my lord. Now, my lord, what is the impediment in front of me, my lord? I had participated. I have a better academic record than most of the participating candidates. I had performed very well in the interview process. Now I am being empaneled as a third candidate, my third empaneled candidate. 2 candidates have been appointed without my knowledge. No result was published by the college authority. I had made the RTI application in the month of February 2024. Their submission on the last occasion was that they had maintained the rank-wise merit list, but did not supply us. After filing this petition, they have supplied me the rank-wise merit list. But with regard to the rest of the queries, nothing has been done, my lord.
What are the other queries?
My lord, I would like to bring your lordship's attention to query 6 and query 10, my lord. Please give me the details score sheet, academic and Wi-Fi both in details as per the score pattern.
Why
of all.
is it not reflected in the final merit list, the score sheet?
No, my lord, the detailed score sheet.
Show me.
Lord,
Show me, where is your...
my lord, on the last occasion, the college authority had supplied to your lordship, my lord. It only contained the marks, my lord.
Not the breakup?
No, my lord. No, my lord.
Who is for the college?
On the last occasion, someone appeared, my lord. Your Lordship's last order was to file a report of compliance.
The college was directed to upload the score sheet, including the breakup of marks. That has not been done.
No, my lord.
Of all the candidates in the official website, Achanan appears on behalf of the college. Stop. Let a further notice be issued. Stop. List on 22nd, next Wednesday. Record your appearance.
Mr. Somnath Ganguly.
Your name will be recorded. All right. 95.
Well, I am the petitioner.
I'm the respondent state, my lord.
Yes. What is the matter?
The matter was.
Oh, similar order was passed today.
Yes, my lord.
Which item?
Number 83, my lord.
Same order as item 83.
My lord, this has to be submitted report. On the earlier occasion, I submitted the report, your lordship.
If it is there, it is there. Call 96 months.
Grateful, my lord.
96, I am for the 96, I am for the petitioner lordship, Mr. Mujibur Ali Rahman appearing this matter. Mr. Mujibur Ali Rahman appearing this matter. So he is suffering from fever lordship. Kindly make it not.
Hello, this is a group 4 matter.
Group 4?
Group 4 matter.
The classification sheet mentions presentation form also mentions group 9. I do not know.
It's a customs matter, my lord.
Yes.
Can you see that cost title? Chief,
when will he come?
Tomorrow, fixed.
Only not today? Tomorrow to be mentioned, place korun to.
Okay.
Yes. Yes, 97.
I appear for the petition.
Who is your other side?
It was directed for filing of report. Report has been filed. Then
Exception do you want to take?
no exception.
No.
My lord, I can make submissions, my lord, on the basis of the.
On the basis of the report. It is not here.
So we'll recollect there was the initial assessment that was done. Now
Whatever,
it was
get the state, please. None appears for the state. Is there any other party?
No, only state.
Only state.
Only state.
Let notice be issued. List on next Wednesday, 22nd.
As well as. তুমি নোটিশ দিয়ে দেবে কে নীলম সিং
Lord, Mr. Devabrata Roy is appearing for the petitioner. He is engaged in another courtroom.
I am
If Lord
appearing
kindly
on behalf
makes it
of
not
state.
today, my lord. 98 and 99, my lord, both matters.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. List in the combined monthly list of February. Record your appearance, please. Yes, 98, 99, same order.
Your Lordship.
Give your appearance.
Your Lordship, may I have your kind leave to mention the matter, item number 89?
This is not the time for
No, Lordship,
mentioning.
not mention. My matter is dismissed for default. Your Lordship,
If
I
you're
am
not
for the
there, what
petition.
can be done?
Your Lordship, my counsel in the matter is Rudraman Bhattacharya. He is not well. He is suffering with viral fever, 103
Court
degrees.
is not supposed to know who is suffering from viral fever.
Your Lordship, I was
Should
stuck.
have been there.
I really apologize, Your Lordship. I was stuck in some other court, Your Lordship. Kindly, Your Lordship.
Which item?
89 of the monthly list, Your Lordship.
89.
Yes, Your Lordship.
Somebody was there.
For the respondents, Your Lordship,
Yes.
I was stuck before some other court, and my counsel in the matter is not well. He's not attending court, Your Lord.
Other side, then the order will be recalled. Only if your other side, you can get hold of him and bring.
Grateful.
Then only it can be recalled.
My lord, on the last occasion in item number 99, fresh writ petition is to be served, my lord, upon the respondent, my lord. But they have not served upon us. I'm for the state, my lord.
If the order is there, it is there.
My lord.
It will appear in the next month list. Yes, call 100.
99, I am appearing.
Lord, 100, my lord, I appear on behalf of the respondent number 2.
Yes, there was a request for adjournment. Next monthly list.
Next month list.
100, my lord,
I appear on behalf of the respondent number 2 in this matter, my lord, and my lord, on behalf of the DM. So I would like to use one of pleading, my lord, annexing the report of the
I think
DM's
respondent should not
report.
submit first.
Lordship, one thing, Lordship, one point. We indicated that a writ petition against Red Cross Society is not maintainable. It is decided by the
Maybe, but
my lord, in this matter, my lord, I beg to appear on behalf of the respondent number 2. Affidavit has been exchanged.
But the affidavit of reply is with me. I have served them. Now they have nothing to say without except mental immunity. My lord, they have. My lord, the state is to file. The state is the main party here.
State cannot be held to
Well, yes, because district
my lord,
magistrate
can
is the
hear me?
president. Why are you prescribing? District magistrate is the president. I will show your lordship.
74
1 minute. Somebody is there for the state.
My lord,
My state is appearing, I think.
I am appearing for respondent number 2, led by Mr. Supratim Dhar, learned senior advocate, is appearing through virtual mode.
Yes. Where is your report?
A report already been filed previously, and in my reply, their report has been annexed also. In the report, the district magistrate had clearly said that they have not been informed of the next meeting, on the basis of which a new list has been prepared, and the district magistrate should file a reply regarding this. I think they will file it within a specific period.
Yes, my lord, that is on the way.
The impugned
For
notice,
today,
which is impugned
my
here.
lord,
That is
kindly postpone it to the next
that is the page,
Wednesday. In the
33,
meantime, my lord, we will
Yeah.
file our affidavits. Order passed on last occasion, Lordship District Magistrate, who earlier directed the bank by mailing that stop the all accounts, she has instructed to the bank to open the account and operate the account. Wherever this particular scheme of this act says there is no control of the.
Man, may I submit because it is the respondent submit.
Today I am virtually appearing.
No,
My lord,
my lord has
kindly make it not
directed.
today.
My lord
I'll
has
do it on
directed the
tomorrow.
district.
If Mr.
Yes,
Chatterjee,
my lord has
if
directed.
Mr. Chatterjee has
My
so
lord has
much of
directed the
problem,
district
then
magistrate
I can do
to
it.
give the salaries, and also the day-to-day affairs are required to be maintained. Nothing else than that. Yes, he is entitled. She is the president here, and she is the president. She is not being informed also. She is the president. She has not been informed also. That she has already admitted in the report that she has not been informed. Anything.
A group section.
My lord, I am showing the report. I am showing the report, my lord.
Society now in connivance with the state and particularly DM is doing all that.
No.
And he is doing all this.
My lord, I am showing the report.
Reply against the
Even the state has the authority to.
Which portion it has been held?
Let them give me a copy. I will.
My lord, let me.
The normal
My
decorum.
lord, let me use my
Now they will
pleading.
come with a judgment and say this is not
My lord,
maintainable.
let me come back with my pleading.
When your
What
lordship
Mr.
has admitted it,
Chatterjee's-
yes, I have. Let them give a copy. They are relying on it.
Kindly come. 2016 SCC Online Gujarat 7916.
Which
What is that?
portion?
Kindly come to paragraph 74. So far as the case in hand is concerned, and I have observed earlier, although a district magistrate could be said to be the head, the district branch, yet I do not find anywhere his role of any nature. So far as the respondent number 1 is concerned, neither the order of the appointment was issued by the district magistrate nor the order of termination. Lordship, kindly come to paragraph 75. Learned counsel attended on behalf of the state also relied upon a decision of the Supreme Court in the case of UP State Cooperative Land Development Bank Limited versus Chandrabal Dubey. The issue before the Supreme Court was whether the UP State Cooperative Land Development Bank was amenable to the writ jurisdiction of the High Court or not. In the said case, the respondent was working as the branch accountant of the Nowpur branch district concerned. Now, Lordship, kindly come to the concluding paragraph, paragraph 85. Paragraph 85 says, I take the notice of the powers of the Executive Committee of the one has provided the Constitution and an extra charge that we employ lay or suspend. 86. Having given the anxious thought the consideration to very ticklish issue, I finally conclusion as under. If a particular society can be characterized as a state within the meaning of the Article 12 of the Constitution, applying the test evolved by the Supreme Court in that behalf, it would also be an authority within the meaning and for the purpose of Article 226 of the Constitution. In such a situation, an order passed by the society against its employee in violation of the statutory rules or bylaws can be corrected by way of writ petition. This is not because of the bylaws have the force of law, by on the ground that having framed by the bylaws prescribing the service conditions of the employee, the society must follow them. in their interest and fairness, if it is left to the sweet will and pleasure of the society either to follow or not of the bylaws, then lordship kindly come to 2. In the case in hand, neither the statutory rules governing the appointment nor the removal of the employee of the society, nor any bylaws, if any, have been placed on record, nor even relied upon by behalf of the petitioner. Let me for the time being assume there are rules, bylaws for the purpose of appointment and removal of the employee. They would be in the nature of a contract, terms of the contract, such and such society, and 226 was in an appropriate case if the violation of the statutory public duties established. Mandamus, certiorari, and prohibition are public law remedies. They are not available to enforce private law rights. Every act of society which may be the state within the meaning of Article 12 does not necessarily belong to public law field. A society which is a state may have its private law rights like a government contractual obligation, which is not statutory, cannot be enforced by way of. Therefore, the writ petition is not maintainable.
Yes, yes, that on the basis of reading that judgment, that cannot be. Let me deal with that judgment also. Well, let me deal with that judgment also.
Affidavit in opposition
My lord, respondent number 2 would like to
on behalf
use
of
an
the
affidavit in
respondent
reply.
numbers 4 and 5 and the reply thereto by the petitioner are taken on record. You,
Respondent number 2.
My lord, respondent number 2.
My lord, since he's not audible, my lord, we would like to use the affidavit in reply against the affidavit in opposition filed by the private respondents, my lord.
reply against the opposition filed by the private respondent.
My lord.
Yes, I need to deal with my lord, kindly.
The party
Sir,
appealed.
Is a party.
No, no, no. আপনি সবসময় চিৎকার করলে তো হবে না। No, because the district magistrate is a
My lord,
party.
may I? My lord, if I am at all audible,
District magistrate is allowed to
Counsel
say. Why are
representing the
they are
district
fear of
magistrate,
the district magistrate?
seeks time to file affidavit in the matter.
Why they are fear of district magistrate?
Stuff. Next. Let affidavit be filed by the district magistrate. How soon?
my lord, by tomorrow or day after.
Why?
My lord.
Why
Ready, my
so overzealous?
My lord, it's ready.
They are ready.
Lordship, I have
But
one
there are allegations
listed
against
application.
district magistrate, my lord.
Ah,
I
achha.
need to deal that. My lord, since there is an allegation
Within
against the DM.
24th. Within 24th. Let the matter appear in the list for consideration on 31st of January.
Lordship, one I have connected application I have filed.
Achha.
Lordship, kindly
An issue
direct-
has been raised with regard to the maintainability of the writ petition by the
But they should give me the judgment also.
Lordship, they
There is an unreported
Find
judgment.
it out.
by the
No, no, there is
Red
an
Cross
unreported
Society.
judgment.
It's not unreported.
Yes.
2016
Stuff.
SCC Gujarat.
The judgment relied upon is in the matter of Manoj
Page number, sir.
Ambaram Kahar একটু দেখে নেবেন বানানটা versus Indian Red Cross Society and 2 others reported in 2016
Page.
SCC online Gujarat 7916.
Sir, what is the record?
Lordship, only one thing, Lordship, I filed a connected application.
It will appear
Now, my lord, what thing they have done? The opposition has been filed. They are by them by the respondent number 4 and 5. 4 is a staff and 5 is the Red Cross Society.
Yes, I'm authorized.
Both of them. And they should
You are
show their
nobody now.
authorization.
You are nobody now.
achha,
Grateful, my lord.
application is already there.
My
It
lord,
will be
it will appear on
Only-
31st.
31st for hearing.
No, only in place of 31st, maybe any
31st is a Friday. This is the reason. In that case, 7th of February.
my lord.
7th of February.
For hearing, Lordship, it would be
Yes, for hearing.
Deeply obliged.
hearing top.
Deeply obliged.
Let me see. Yes, call the next matter, please. 103. Na koto 101.
This matter.
My lord, I'm appearing for Bar Council of West Bengal.
Yes. Is the petitioner there? Dismiss for default. Record your appearance, please.
My lord. Grateful, my lord.
এটা নিয়ে এটা নিবেন not today only এটা নিবেন
Dismiss for default.
এটা নিবেন Union of India led by Mr. Anil Kumar.
103.
For the bank in this matter.
Yes, my lord. I am the petitioner appearing in person.
Yes.
My lord. My lord, earlier occasion, the both the private respondent mislead the honorable court.
Misled?
Yes, my lord.
Yes.
They impose NPA account upon me, but I did not get car. This is the policy. Until hand over the car, bank cannot impose and deduct amount from my account.
If you do not take possession of the car, what can be
No,
done?
no, my lord. This is their responsible.
Several
Yes,
responsibility.
my lord. This is the yes, my lord. I am giving judgment.
Are you judgment? Show me the law first. You going to the judgment. A car is ready for delivery. You do not take possession of
No,
the
my
same.
lord. Not first time. The dealer promised me 3rd November 2020 they will be delivered. Then thereafter they did not deliver. 6th November 2020 that will be delivered. But 5th November they inform me they are unable to deliver. Then thereafter I reply through mail. If 6th November 2020 deliver not deliver, then I will not get car. Then thereafter 6th November 2020 they inform me, yes, we will deliver. You come to the showroom. Then thereafter, and also you complete insurance.
So
within
you
few
went
minutes,
there.
Yes, within few minutes I complete insurance and send to the dealer. And thereafter I reach 3 p.m. for taking delivery. Then thereafter they complete all process, and evening they completely told we are unable to deliver this car. Then thereafter next day 7 November I went to the Topsia police station and police personnel called them. Then thereafter,
why did you go to the police?
Because they harass me and very bad language uses. Then thereafter 7 November I went to the police station.
Who is for the bank?
I am for the bank.
Yes.
My lord, we have disbursed the entire amount into the dealer's account.
Dealer.
Dealer.
You sort it out with the dealer?
No, my lord, we have disbursed the entire account, and thereafter, my lord, there is no scope for us, my lord. Kindly appreciate. There is no scope for us to say. My lord, on the last occasion, my lord was pleased to direct me to the bank to see whether some
can be
settlement can be
settled,
done.
yes.
My lord, as of date, my lord, the amount is more than 3 lakh. So the bank has offered him a proposal. It can be settled at
Where is
1 lakh.
the proposal?
My lord, I am having it.
Is the petitioner aware of the proposal?
My lord, he has been mailed. My lord, can you see the?
They mailed 18 December. But your lordship directed 5th December.
If you take all these points that they were to do it within today, they have done it tomorrow. The car was to be delivered today, they will deliver it tomorrow by a delay of 1 day, and you will just turn around and say, I won't take.
No,
then
my
it
lord,
becomes
this is
difficult.
this is not fact.
Are you aware of this? Are you aware of the proposal of the bank?
Yes, they have mailed to me.
I
A
personally
delayed,
the bank to send
a delayed mail
Yes.
came to you?
Yes.
Are you agreeable to whatever proposal they have given?
No.
No.
I'm not agree.
Yes.
Because I am showing one judgment. Kindly see.
I will not see a single judgment. You are not agreeable with the proposal?
No, my lord. My
If
lord,
they-
just one thing. I have come before your lordship as per direction of the NCDRC, being transfer of the application, transfer application, because the district commission has biased. During the pendency of the case, they repeatedly pass biased order. Then thereafter, I filed.
The court was trying to see that you can get relief over here only. Since you are not agreeable to any proposal,
I understand.
then there is no use in keeping the matter pending.
The district commission matter already disposed of, rejected with cost. But during the pendency of this case, the district commission could not do that.
Why? Was there any stay order?
No.
Then
even if it did not stay order, then thereafter they did not could not do that, because I have judgment in this honorable court. Yes, my lord.
No, I am not interested to look at any judgment. I told you at the very first beginning. I am not interested. If you are aggrieved by the order of the commission, the state commission, go and appeal. Please come.
My lord, just one thing. I have filed an application of matter is stay by the state commission now.
Petitioner approached the District Consumer Redressal Forum. with his complaint. He alleges bias on the part of the district forum. During the pendency of the complaint case, the writ petition was filed seeking transfer of the complaint case from one commission to the other. By the time the writ petition could be considered, the commission has
even three-time
disposed
intimation.
of
Even three-time intimation, my lord.
disposed of the complaint case. The petitioner is aggrieved by the same. It has been submitted that the commission ought not to have proceeded with the complaint case as the writ petition was pending before the court. Paragraph. No order of this court has been brought to the notice of the court, staying the hands of the commission in proceeding to decide with the complaint case. The complaint case was decided on merits and disposed of. In the event the petitioner is aggrieved by the as the petitioner appears to have been aggrieved by the order passed by the district commission, it will be open for him to approach the appellate forum for relief, if so advised.
My lord.
Writ petition stands disposed of.
My lord. My lord, kindly give me one. Kindly direct state commission within 2 months that will be disposed of.
Yes,
I have
call the
filed.
next matter.
My lord, 103, my lord. Mr. Sushantopal is appearing for this.
103.
104, my lord. I am for
Three,
the
my-
petitioner.
104.
3, my lord.
Yes, it has been disposed of. You are appearing for the state.
State, my lord.
Give your name. It is your name that will be recorded. Yes, 104.
I appear for the bank, my lord. Lordship on the last occasion directed me to put my stance on a settlement proposal on affidavit. But
affidavit has come, Lordship. I have taken the instruction, Lordship. I want to use another affidavit, Lordship, not in order to controvert, but since it's my client's statement, Lordship, may I get 1 week time, Lordship.
For what?
That what's done, because whether he is accepting this or not, because ultimately it's
December, my lord.
We have to settle it.
There's an order of the district magistrate.
Because according to him, this particular figure is reducing some time, because there are differences from the earlier claim and their
my
present
learned
claim.
senior friend wants to go into
So I don't
merits,
want
my
to
lord.
get into it.
If merits are being argued, my lord,
1
then I'll
minute.
argue, my lord.
I see a proposal for settlement by way of an affidavit from the end of the first and the second respondent be placed.
Yes,
That
I
is
have that
there.
affidavit. I have served that.
And are you accepting the proposal?
One instruction, written instruction I want to use, Lordship.
Give
You will kindly keep it, Lordship.
the affidavit by the
One and
first and the second respondent is taken on record. Stop. Copy of the same has been served upon the learned advocate representing the petitioners. Stop. Learned counsel for the petitioner seeks time to take written instruction from the client. Stop. Next Tuesday, 21st.
Grateful.
One 105.
Lord, Mr. Nag is leading me in the matter. Ruankar Nag. His son fell down and he has a injury.
Yes,
He's
my lord.
doctor, my lord.
Yes,
Can
my lord. I appear for R6. That's true, my lord. Kindly keep it on some other day.
My lord, I appear for the IBB.
So the affidavit of service may file it, my lord, and come back after a week, my lord.
Affidavit of service filed in court is taken on record. Stop. An accommodation has been sought for by the learned advocate representing the petitioner. Stop. Next monthly list, I'll post it.
Very well.
Next
Very
month. It's the matter in the next monthly list.
Grateful.
106. $107, is anybody there?
In the last occasion, my lord, Mr. Shane appeared, my lord, for the private respondent, my lord. My lord, a mobile tower, the installation of a mobile tower, my lord, that was the dispute. And my lord, your lordship, my lord, on the last occasion, my lord, advised me, my lord, if my client is willing, my lord, to file to file a grievance, my lord, before the appropriate authority, my lord, as per the amended act. No, that instruction has yet to come. My lord, accordingly, I advise them, my lord, to file an application. No, that instruction is yet to be, my lord, received by me.
Learned advocate for the petitioner seeks time to take further instruction from his client. Stop. List in the combined monthly list of February.
My lord, item now 1010. I paid for not today only. We have the petition.
No, my lord, I'm appearing. I'm appearing for the petitioner for 109.
108 কি হলো?
109.
108 হয়ে গেছে? আগে হয়ে গেছিল? আচ্ছা ঠিক আছে 109.
109. Yes, Mr. Newg is.
I'm for the petitioner, my lord. I'm
Yes.
for the petition. My lord, I am a bereaved son, my lord. My father was an employee of the Port Trust. Now, my lord, the death come retirement gratuity, my lord, that is being given to my mother in 100%, my lord. I only want my proportionate share, my lord. If it is given to my mother, I would be deprived, my lord. That is, my lord, kindly come to page number 20. That is the order of the Port Trust that has been given.
Page number 21.
20, and yes, my lord. 21, the relevant portion, that is in the last para, my lord.
Last paragraph, Lordship.
If this is as per the declaration of the employee, then what can be done?
Correct.
My lord, according to the order that has been settled by the Honorable Supreme Court, my lord, in the case of Shipra Sengupta versus Midul Sengupta, that is SC 2009-408. My lord, that is saying, my lord, the legal heirs they will be getting the proportionate share of the deceased employee, this death come retirement benefit, my lord.
What is your
regulation? I will so prior to that, my lordship, can you see the page 21?
Yes.
Last paragraph. What is the attitude to his mother? Then I will show to the regulation.
Petitioner's name is Arjun Hela.
Arjun Hela, yes, my lord.
What is the lordship? Can you see last paragraph, page 21?
Mother, what is the name of the mother?
Mother name Manju Hela.
Manju. In her submission is requested to release family along with entire
Mr. So and so, entire death so and so. But after the name
Yes, I've seen.
Yes, ma'am. Now the regulation says that those persons, the deceased employee, at the time of his employment, he nominated the mother, his wife. So according to the regulation, who will be nominated, he is entitled to the entire death come retiral benefit.
But does the nominee hold back the entire money, or
Nominee
is
holds.
the nominee responsible for?
Regulation, kindly see 36. I have mentioned in the impugned order. As per the regulation 36, my lord.
Please give.
Nominee is entitled.
Let me see.
First, an employee shall on his initial confirmation in service or post make a nomination in the form as may be as appropriate in the circumstances of the case.
1 minute. 36.
36.
Nomination. To receive the death claim, the employer of the family nomination shall not be in favor of any person other than the employer. ঠিক আছে, এখানে employer nominates more than one person who shall specify the nomination, the amount of share.
Then who is the family? If not family, then their condition is there. So in his family, he nominated his wife.
Yes, what is the submission of the petitioner? It has been done according to the regulation of the Port Trust.
My lord, as per the decision of the Honorable Supreme Court, the nominee is the only custodian of the money, whatever is given.
Very
But
No.
my lord,
It is only the custody.
The petitioner challenges the order passed by the senior accounts officer within bracket pension by holding that the widow of the deceased employee, being the nominee, is entitled to receive 100% death cum retirement gratuity, and the same has already been released.
That, my lord, I have no instruction whether it is.
All right, and the same will be released, and the same is to be released in favor of the recorded nominee.
Namely, Monju.
Just stop. Next, learned counsel representing the Port Trust Authority relies upon Regulation 36
Yes.
of the Calcutta Port Trust Employees apostrophe within bracket pension regulations, 1988, which mentions that an employee shall, on his initial confirmation in a service or post, make a nomination in form as may be, as appropriate in the circumstances of the case, conferring on one or more persons the right to receive the death cum retirement gratuity. Regulation 36 within bracket 2 mentions that if the employee nominates more than one person under subregulation 1, he shall specify in the nomination the amount of share payable to each of the nominees in such manner as to cover the entire amount of gratuity. Paragraph. The petitioner submits that he is entitled to a share in the gratuity amount. Stop. Paragraph. It appears that the employee nominated only his wife to be his recorded nominee. Stop. Had the employee intended to give any share of the gratuity amount to any of his other family members, then the employee should have mentioned the same in his service records. Stop. Paragraph. The service records of the employee clearly records the name of the of his wife, Monju Hela, as his nominee. Stop. The Port Trust Authority, being the employer, rightly disbursed the entire amount in favor of the recorded nominee. Stop. Paragraph. In the event the petitioner intends to have a share of the said amount, then it will be open for him to approach the competent civil forum for remedy. Stop. The court is not inclined to exercise jurisdiction in this matter. The writ petition inclined to interfere with the impugned order. The writ petition fails and is hereby dismissed.
All right, might take back the regulation.
Yes, take back.
My lord, one indulgence, may I be given a copy of the regulation? May I be supplied with a copy of the regulation, my lord?
No, you can obtain the regulation. It is there everywhere. You can get the regulation.
Available in the website also.
In the website also it is available.
Lordship,
Yeah,
grateful.
motion.
Your Lordship, serial number 89, my respondents are here, Your Lordship. The advocates for the respondents.
Who is the advocate for the respondent?
The added respondent number 4, Your Lordship.
There were other respondents also, isn't it? Senior counsel was also representing.
Joydeep Kaur was there for
Well, it's
the answering respondent.
it was a writ petition. It's a writ petition, my lord, a tender matter. My lord, sorry, I had a doctor's appointment, so I could not be there. So I had to go. So, my lord,
No, but then nobody was there also to make submission on behalf of the petitioner. The court has dismissed the matter in the presence of
I
the
will have
learned counsels for the respondents.
But I would
And
beseech
I have informed the learned counsel who is present over here to get hold of the advocates of the other side so that it can be restored in their presence.
my lord, I do understand. I do apologize, my lord.
I am
My
still
advocate
here.
on
You get hold
record-
of them.
Your Lordship, for the state, Mr.
Only state will not do. There were other respondents also. So please get hold of them or their juniors. Senior counsel was present. Get hold of them. You come. I am here. Please come and mention. I'll see. Yes, call the list.
100 my lord, I'm for the petitioner. My lord.
Yes.
I'm saying not to them. My lord.
Lordship,
Mr.
I'm for the
Samrat Chaudhary
respondent.
appearing in this matter due to ill health, my lord. Today is unable to appear. My lord.
Lordship, I'm
It
for
will go to the monthly list in its original position. No upgradation. Please come.
Lordship, I'm
My
for
lord, kindly
LIC,
not
right?
to them.
The matter was mentioned citing urgency. Stop. The same is appearing under the heading upgraded motion. Stop. At the time of call, accommodation has been sought for by the learned counsel representing the petitioner. Stop. The matter be added in the list of motions in the monthly list of February 2024. 25. Call the next one. Record your appearance, please.
111, my lord, I am for the petitioner, my lord.
Yes.
In this matter, my lord, the petitioner, my lord, is a very poor lady who is belonging in the Baul Sampradaya, my lord. She has an account in the United Bank of India in Tatla branch, Nodia. And she made a fixed deposit on 7 lakhs.
Anybody representing the bank?
Yes, I represent the bank.
Yes. 7,50,000 in Tatla branch. Thereafter, my lord, she shifted from Nodia to Dankuni, and there, my lord, she has another branch. She has opened an account. Thereafter, she has written a letter to the Tatla branch manager that kindly transfer my that 7,50,000 after maturity. But kindly have a look into that representation. Thereafter, the manager of the Tatla branch means Dankuni branch also has written a letter to the Tatla branch. Thereafter, my lord, that was withheld from 2020 to
25?
Yes, my lord.
The amount has matured?
Yes, my lord.
My lord, this is a
Mature, my lord.
And it is the same bank only from one branch to the other?
One branch to other.
Lord, this is a lien marked account, my lord. My lord,
Why?
kindly takes a communication, my lord, that the bank has received from, my lord, the office of the block development officer, my lord, Nadia, where, my lord, this lady, my lord, this is the bank has been informed after copying that, my lord, this lady was responsible for holding funds of a my lord, trust, my lord, and my lord,
There is no question of
and my lord, this money has been allegedly misappropriated by her, and this is that same money.
No, my lord,
And
this is my private property which was sold by my deceased husband property. I have sold, and that my lord, I have annexed all these things.
Listen, the court will not go into all these details.
Yes, my lord.
Then you have to go to the civil forum to get an order against the bank.
Kindly have a look into. I have annexed
Whatever
all
it
these
is,
things.
if the allegation is such which you dispute, then what can be done?
Let them.
Some Shyam Sundar Ashram's fund was with her.
No, my lord.
And the villagers, but I am not against her. I mean, I'm a nationalized bank. A public office has informed me, my lord. I have taken steps, my lord. Let BDO be.
Private money, I have. My lord, kindly have to look into. I have given
The petitioner prays for transferring her bank account in the Bank of India from one branch to the other. Stop. Learned advocate representing the bank submits upon instruction that the amount which the petitioner is holding in the bank has been reported to be a misappropriated sum of an ashram. Stop. A complaint was lodged by the ashram before the bank, and the bank has maintained a lien over the said amount.
The complaint was before the block development officer.
A complaint was made before the block development
branch
officer.
has not given any kind of intimation to me also, my lord, till 2020-25.
And the bank has a lien.
I have annexed the sale deed also.
Over
My
the
lord,
said
what
amount.
property I have sold.
Yes, ठीक है sir. Learned advocate representing the petitioner asserts that the said money is the private money of the petitioner, which she received upon sale of one of her properties.
Yes, my lord. My deceased husband property, my lord.
One of
P2.
One of the properties of her deceased husband.
Yes.
Stop paragraph. It appears that the bank is yet to communicate the reason for not transferring the bank account to the petitioner. Stop paragraph. As disputed questions of facts have been raised by the parties, the writ court is not inclined to enter into or adjudicate the same on merits. Stop. The branch manager of the Bank of India Tatla branch, TATLA, is directed to intimate the petitioner the reason for not transferring the bank account of the petitioner as per her request.
And withholding
at
also.
the earliest, but positively within a fortnight from the date of communication of this order. Stop. It will be open for the petitioner to approach the competent forum for remedy of her grievances. Writ petition disposed.
I'm deeply opposed.
But I appear for the petitioner.
Yeah, this side is not here once again.
Mr. Shukanto
Very
Chakraborty
difficult.
was earlier heard.
Heard? Who is there for the other side?
He didn't appear on that day.
Last occasion also nobody was there. Let me see.
The 2023 motion.
Yes.
Was taken up just before the long vacation. On that day also.
There was a direction for service upon Mr. Shukanto Chakraborty.
Yes, that we have given. We have intimated him.
What is your prayer?
But this is the focus product scheme which was prevalent in 2009. That was the notifications issued under the Foreign Trade Development and Regulations Act export-import policy. Now, on certain items, there are some benefits to be provided to the exporters. Now, there is a modifications of that policy. On 21st of October 2011, a notifications came. By that notifications, the benefits was limited to a particular group of items. Not in earlier it was given to a number of items. It was limited. Only 33 items. Now after that, prior to that, these notifications, the government sought to give effect to this effect of this notification from April. Now that was challenged before this Honorable Court, before a learned single judge by other petitions. Learned single judge held that following the Asian Foods, that it cannot be, it should be effective from the date when it was published. In case of the petitioners, that benefit prior to that 21st October 2011, those benefits were not given. But ultimately, their applications were placed before the policy relaxation committee. In 2021, kindly straightway come to page 63. The first order.
Yes.
Case number 94, as you also got it.
Yes.
I will also, the first portion, it narrates the fact with retrospective effect from 1st April 2011 that no export benefit of 2% as FPS will be provided to the exporter or product of technical textiles. Now, and later on 4th March 2013, one more notice was issued which instructed to recover if any exporter had taken incentive against the exports of technical textiles. Their sister concern firm Eastern Traders challenged the notice in High Court, who ordered that the writ petitioners are rightfully eligible to claim incentive before 21st October 2011. I have annexed that judgment also. And the order cannot be imposed retrospectively. Hence, on the basis of these orders, they are requested to allow FPS benefits against the aforementioned 5 files. Those are for the present petition. Decision. Now, the committee, I don't know why, the committee went through the statements made by the firm and noted that the applicant has not submitted any cogent reason justification in support of any genuine hardship faced by them. Accordingly, the committee decided to reject. I don't know what genuine hardship they were talking about. These benefits were payable to us, it was denied. Now I need to show that because of non-payment of this benefit, I suffered hardship. This is not, this is as per policy I was entitled to.
Show the policy once.
Yes, this was reviewed also. There was a provision for review also. Now kindly take page 66.
Yes.
The last case is PH case 07, has the lawsuit got it?
Yes.
Now the next page.
Yes.
Just saying, just decision, you also kindly took note of the decision. The committee heard and reviewed the case on the basis of the justification furnished by the firm along with report received from RECO. After detail it observed there is no merit in the firm's content and has decided to maintain rejections of the earlier decisions. Both these orders are first, they are non-speaking orders. Virtually these are not the reasons. Now kindly take the policy. At page 23. Relevant would be 24. Yes, 24 kindly come. This is the focus product scheme, 3.1.4. Last 3.15.2. Exports of notified products as per Appendix 37D of HPV 1 to all countries shall be entitled for a duty credit scrip equivalent to 2% of FOB value of the exports. This is a monetary sum. Now the kindly see the objective. Objective is to incentivize the export of such products which have high export intensity, employment potential, so as to offset infrastructure inefficiencies and other associated costs involved in the marketing of these products. These are the objective. There is no question of hardship. Now these kindly take the page 29. This is the notification.
This matter is to be heard. It has to be heard on merits. It cannot be done at this motion stage. And that
I just kindly take one smaller. This is the restrictions imposed 21st October 2011 and the judgment of this Honorable Court. It was not appealed against, they have complied with. Page 39. Kindly first take page 29. This is the notification of 21st October. The top, you also will get the date 21st October 2011. Now these 33 items have been specified which was restricted to. Now kindly take the page 31, this is appendix 37D, which was modified.
Page number change.
My lord, kindly take, my lord, sorry, my lord, this is wrong, my lord, page 32, this is a 37D appendix. My lord, this was modified, serial number 183, page 32. Technical textiles, woven fabrics or synthetic, 33 categories as specified in policy circular dated 21st October 2011 with effect from actual 1st April. Now, on this, my lord, kindly take the judgment of the learned single judge of this page 39. My lord, I am not the same facts. Kindly take page 40, my lord, below. To my mind,
Yes.
to my mind, two other points are involved here. The first is promissory estoppel. The exporter, on reliance of the earlier interpretation, enforcement of the policy, made exportation of the said goods with expectations of earning duty benefits which were earned on previous occasions. On that basis, he exported on these goods. Secondly, well, I'm just keeping two lines. Secondly, an administrative actions should have finality. When goods are legitimately exported under the existing policy, duty is earned. The government takes a decisions in clearing particular exports which results in earning of this duty benefit. These decisions at the point of time is to be taken as final in normal circumstances, cannot be reversed at a later point of time by change of interpretation of the descriptions of the goods by a policy circular with retrospective effect. Learned Counsel for the central government took the point of existence of an alternative remedy. It was argued that the remedy lay under foreign trade development. I am not impressed with this submission in making and publishing the above notification dated 21st October 2011, issuing the said notice dated the respondent authority have traveled outside their jurisdiction. The notification is against the above law laid down by the courts. Therefore, I do not think that the so-called alternative suggested by learned counsel for the respondent would at all be efficacious. For those reasons, these writ applications are allowed to that extent that the respondent authority are restrained by an order of injunction from denying any duty benefit to the writ petitioners earned by virtue of the exports of goods understood by the parties as technical textile before 21st October 2011. The notice is issued by the department to deny duty benefit to the writ petitioners and making a demand for reversal of the duty benefit are without any effect for export before 21st October 2011. I make it clear that the respondent authorities will be free to proceed in accordance with the said policy with regard to the exports on and from 21st October 2011. This was acted upon in respect of the Eastern traders. They were given the benefits up to 21st October. Your Lordship is well aware of the, I can cite two judgments of the Supreme.
But in the absence of the other side, do you think it will be proper?
It was never that I did not export it legitimately.
No. This was all these exports were done when it was permissible. And
I understand, but your other side is not here today. This is what I was wondering. There is a direction for service of notice upon Mr. Chakraborty. You give one notice and come back. I'm fixing it on next Tuesday. None represents the respondents. Notice was directed to be issued upon Mr. Shukanto Chakraborty, learned advocate for the Union of India. Stop. Was any notice issued? In September.
It was served upon the respondents. The affidavit of service have been filed. I'll
let a further notice be issued in the office of the Union of India, 11 Strand Road. Don't write the address you serve. 11 Strand Road, somebody will appear. List on 21st.
Probably, my lord, they will not appear. My lord, it is.
This has been served upon.
My lord, it should be. Can we see the last order?
Mr. Shukanto Chakraborty.
Upon Shukanto Chakraborty.
Sir, at least somebody should be here. There is a direction for serving upon Mr. Shukanto Chakraborty. Yes, call the next matter, please.
এই judgment গুলো আছে নিয়ে আসেনি বইটা
I am appearing for the petition. In this matter, my lord, I have.
Is your other side here or not?
Samrat said along with Miss Amrita Maulik is appearing. My lord, I have caused to inform her yesterday also. The notice is also there. And
a recalling has been allowed. So what is the issue in the writ?
recalling has already been done. My lord,
Yes, what is the issue in the
my lord, the
writ?
issue is, my lord, regarding the disproportionate assessment of the market value of a property for the realization of stamp duty for registration purpose. It is, my lord, lingering since 2005. My lord, this is
You cannot get your property registered because you are not getting
yes, because
the proper market value
yes.
assessment.
According to the, my lord, according to the government, my lord, the market value, it is undervalued. My lord, I can show your lordship. My lord, what happened, my lord? It is a landed property of 19 kata. My lord, it has been purchased in two parts. My lord, one has been purchased in 2005, 9.2 katas, and the other in 2007, 9.8 katas. The portion which was purchased in 2005, my lord, that was, my lord, valued. My set forth value was 33 lakhs, my lord, as per the requisition,
Authority.
and that was based on the.
There was a direction I see on 25th of April 23 in the writ petition filed by you upon the appellate authority, the commissioner, to reconsider the valuation.
Yes, that was done, my lord, pursuant to the direction. My lord, matter came up to this honorable court in 2022, my lord, in 2023, page 107. But Justice Mosmi Bhattacharya was pleased to pass an order in our favor. But see, my lord, if I take your lordship straightway to there, my lord, possibly, my lord, the entire facts will not be. I cannot place it. But this
What
order
is
has
the
also not been
impugned-
complied with.
What is the impugned order, page 113?
Impugned order is, my lord, at page 113 is the operative portion.
Yes.
My lord, what they have done, pursuant to the direction of this honorable court, my lord, they conducted a hearing. They did not touch the market value. They did some depreciation and gave me some remission of the stamp duty. My lord, the property has been valued at 3 crore 10 lakhs. Where, my lord, my case was, my lord, it is 33 lakhs, which was based on the chartered engineer's valuation approved by the State Bank of India as well as the New India Assurance. And the portion, the most interesting thing is, it is one plot only, that is 19 katas. The portion which was registered as per the government valuation only, the other portion in 2007, well, that has been completed. That was also undervalued. We put it 22 lakhs. They made it 1 crore 19 lakhs. My lord, we given to that. How can this property, which is the same property, same plot number, same moja, just the other portion, that they are claiming that it should be 3 crores. And that also, my lord, in 2019 and 2005, I have purchased it. My lord, this is, my lord, absolutely. But that is what, my lord, if your lordship goes through the order of Justice Bhattacharya.
No,
But
I'll
kindly
go
sees
through the
page-
impugned order, the commissioner's order.
Commissioner's order, kindly sees. Commissioner's order, my lord, if your lordship straightway comes to page 113.
Yes.
From the bottom portion,
Will
it
you
will
give
suffice.
one more notice to your learned friend and come back?
Yes, I have served, my lord, yesterday
Who is
also.
appearing?
This is December, but
Oh,
since-
you said Miss Panja Maulik is there.
Yes, yes. And even yesterday, my lord, I had a verbal discussion, but I can understand your lordship's, my lord, difficulty, my lord. In that event, kindly, my lord, let this matter do not go down the list. I can come back as per your lordship's desire on any day by giving another notice.
None represents the respondents despite service. Despite service and intimation of the matter to be taken up by the court today. Stop paragraph. Let a further notice be issued. Stop list on 21st.
Grateful.
May it please your ladyship, I beg to appear on behalf of the petitioner. Here what has happened is, the private respondent, now she is obtaining employment and various positions, my lord, using a fake OBC certificate. But kindly takes page 25 and 26. These are my complaints made, my lord, to my lord, the respondent SDO. But till now, these complaints have not seen the light of the day, my lord. These are my instructions.
Where is your complaint?
My lord, complaints are at page 25 and page 26.
Yes.
Your Worship, I received an inquiry report from the SDO And she is the,
Let me
she
see.
belongs to the OBC category, Lordship.
Private respondent
Lordship.
belongs to the OBC category.
That is reports are also there. Certificate,
Give a copy to your learned friend.
certificate is also there.
Nikki.
Well, may I consider this and come back?
Let me see what is there.
Yes, yes.
Inquiry, cast, candidates, manual certificate, digital certificate. Kukurani Mondal.
Lordship.
Certificate details of Kukurani Mondal. What is the inquiry that has been done? See, it mentions that as per the subject mentioned, it appears from the report of the inquiry officer. Where is that report? That the candidate has original OBC certificate.
Next page, Lordship. Can you page 3,
Next
Lordship?
page.
And certificate is on page 4, Your Lordship.
Listen, certificate may be genuine, but whether the candidate actually belongs to OBC category or not is the query. Here it is mentioned the certificate is genuine. He has not raised issue with regard to the genuineness of the certificate, but the genuineness of the contents of the certificate is under a question mark.
Lordship.
So how will this suffice?
My case was that her parents are not also belonging to the OBC
The
category.
inquiry is not proper.
And my lord kindly takes, my lord.
Does the inspector know how to inquire it? I doubt. Points examined caste identity particulars of the documents. Manual certificate with digitized certificate. This is not the issue. Issue is the caste, whether the candidate belongs to that particular caste or not. This is not the inquiry report. Please come.
My lord kindly takes, my lord, rule 3 and 4. But it is incumbent also, my lord, to give a hearing to me because I am the complainant. This was also not done. My lord is looking at, my lord, the 3 and 4.
Procedure for cancellation, impounding, or revocation of certificate. Order of hearing. Hereby the certificate for the purpose of hearing of the witnesses.
It is recorded here at page 3, Lordship. It is hereby reported that I have been inquired into the above application. During inquiry, I have examined the OBC.
Well, let the SDO come up and, my lord, let the SDO produce evidence that I was also issued a notice.
1 minute. Yes.
Yes, Lordship. Examine the OBC B certificate of Kukurani Mondal. Right? 2 documents examined. There is the examination of the documents.
What about the contents of the document?
Examination of the documents.
Do you get it?
Lordship.
It's not the certificate which is not genuine.
Belongs to the
Exactly. Please come.
But 3 and 4 of the SC/ST rules will apply, my lord, in respect of OBC also in terms of the guidelines.
Achha. The petitioner challenges the other backward classes certificate issued in favor of the private respondent. Stop. Specific submission of the petitioner is that the said certificate was issued contrary to the provision of section a complaint was lodged. A complaint was lodged by the petitioner before the subdivisional officer, which is yet to be disposed of. Stop. Paragraph. Learned advocate representing the state respondents relies upon a report forwarded by the SDO, Tomluk, Purva Mendipur, signed on 2nd May 2024, which mentions that the complaint of the petitioner was inquired. Stop. It was found that the original OBC B certificate was issued in favor of the private respondent and the same was digitized. Stop. Relying upon such issuance, the authority opined that the candidate belongs to the said category. Paragraph. According to the petitioner, the inquiry was not conducted in the manner prescribed in the West Bengal, SC and ST within bracket identification.
Which
Bracket
is,
close rules, 1995.
which
Stop.
is applicable in terms of, my lord, the updated guidelines for issuance of OBC
Yes,
certificates.
yes. Acha, next. It appears from the report that has been placed in court today that the authority only considered the genuineness of the certificate that has been issued in favor of the private respondent. Stop. The contents of the said certificate, and more particularly as to whether the candidate in whose favor the OBC certificate was issued actually belongs to the said category or not, has not been inquired into. Stuff paragraph. The subdivisional officer is directed to conduct re-inquiry to ascertain the proper category of the private respondent. Upon giving an opportunity of hearing to the petitioner and the private respondent. Stop. On conclusion of the inquiry, an order shall be passed and communicated to the parties. Stop. If it appears that the allegation of the petitioner is proper, then necessary remedial measures shall be taken.
Grateful to you, Lord.
Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date
Extremely
of
grateful to you, Lord.
communication of this order. Its petition stands disposed.
Honorable, kindly quash, my lord, the memo
Represents
dated 34/2024.
And represents the private respondent.
Honorable, kindly quash, my lord,
What?
quash this particular memo, my lord, the way that
Memo.
the memo dated 30th of April 2024, whereby they are stating, my lord, that the OBC certificate is in connection with the above mentioned subject, enclosed, please find here.
Nothing to quash over here. They will cause an inquiry.
Very
Nothing.
grateful.
Well, I am for the petitioner. The petitioner is a cooperative society.
Which respondent?
Honored LOI authorities.
Railway.
The petitioner is a cooperative society. He is giving the on-board housekeeping service to the railways. After completion of this work, my lord, he has submitted a bill. The railway authority, my lord, without assigning any reason, have deducted the amount of rupees 1,32,91,477 out of 4,57,44,307. Now, my lord, thereafter, my lord, since there is no reason at all, the petitioner has approached before the petitioner, learned advocate has made a notice upon the railways, page 86, my lord. Then under what extent the such amount has been deducted, page 86. Thereafter, my lord, they have submitted a reply, page 87. On 26 March 2012, page 87. In reference about during execution of the OBHS, there has been onboard housekeeping service, control from 16/10/2008 to 15/6/2010, by the agreement number Sumanso dated 12/12/2008, the following amount had been deducted from your periodical bills. Rupees 71,13,549 as penalty.
So the details have been given.
Given. Now, my lord, I approached before this Honorable High Court earlier, page 89, my lord.
Yes.
Annexure P6, my lord. Yeah, this Honorable Court, my lord, page 90, has observed that railway authorities should reconsider the position on the deduction on account of service tax and communicate the decision to the petitioner within 4 weeks from date. However, it will open to the petitioner to take appropriate steps in terms of the contract to realize the dues. Thereafter, my lord, they have communicated this order, page 92.
Yes.
Now, as per the rules, my lord, the service tax is not applicable in respect of us.
So 2014 order you are challenging now?
No. Thereafter, I made a communication, page 93, my lord.
2014, you reply in 2018.
Yes, madam. But page 93.
No, no. Now let me understand the dates. 2014, there is a reply from the railways.
Because they have not.
And in response thereto, you filed a reply in 2018. Right?
Yes.
Page 93.
Yes, 28.
And then any further?
Actually, the service tax which they have deducted, which is not at all applicable in respect of ours and
The court gave you liberty to approach the competent forum for relief. Why did not you
court has
go?
said to when I file a writ petition, they are not releasing the bill.
Page 90.
Yes.
The court has directed the railway authorities to reconsider the position.
Yes.
And at the same time, it was open for the petitioner to take appropriate steps in terms of the contract to realize the dues. According to you, these are your dues and the railway could not have deducted any amount. So it's a contractual obligation. You should have approached the suit court for relief.
No, not suit court, Malad, because this honorable
Please
court,
come.
Malad, kindly consider this aspect.
Please come.
Malad, kindly see the circular of the railway board, the service tax. Service tax is not applicable in
Very well.
Yes. Paragraph 12, the amount deducted on service tax was refunded to them.
It was also refunded.
Their own statement.
Then only what
Only
remains?
The
penalty portion, my lord. I have completed the service.
The
page 20, page 94, Lordship can see.
The petitioner provided certain service to the railways.
Huge amount of bill, my lord.
At the time of making payment, a sum of rupees 74 lakh was deducted on account of.
Malad, kindly see, Malad, page number P1, Malad, page 28.
71 lakh was deducted for non-supply of material and improper conduct of work. Stop. The petitioner approached this court praying for reconsideration of the amount which was deducted. Stop. আচ্ছা যেখানে 71 lakh বললাম for non-supply of material and improper conduct of work বললাম ওখানে আরেকটা লাইন অ্যাড করুন তো and a sum of rupees 74 lakh was deducted on account of service tax. ঠিক আছে তারপর কি বললাম deducted. Stop. In the writ petition being WP 24493 within bracket W of 2012, an order was passed on 6 June 2013 directing the railways to reconsider the position on account of deduction of the amount by way of service tax. Stop. The petitioner was given liberty to take appropriate steps in terms of the contract to realize the dues from the realize the dues of the petitioners from the railways if they had a valid claim. Stop. Paragraph. In compliance of the direction passed by the court, the railways reconsidered the matter and the service tax amount which was deducted stood refunded to the petitioner. Stop. Presently, the petitioner restricts claim only with regard to the
penalty.
Regard to the non-supply of material and improper conduct of work. Paragraph. The claim of the petitioner stood rejected by the authority way back in 2014. Did you get back the security service tax amount you got back?
But
Where is
the amount which are there? No.
The writ application.
Page. Acha, railway
But
authorities
penalty
refunded the
amount, they
sum-
have not refunded, mother.
penalty amount. আচ্ছা, টাকার অঙ্কটা বলবেন না তো? সার্ভিস ট্যাক্সটা ফেরত দিয়ে দিয়েছে বললাম?
Paragraph 12, কোথায়?
তার আগের লাইনটা কি বললাম? Yes.
But penalty amount is withheld. 1 crore 32 lakhs.
Stop. The subject work was performed by the petitioner in the year 2008. When was the work performed?
Pardon, mother.
When did you perform the work?
2008 to 2014.
From 2008.
And I made a representation, mother.
Stop. The court in the earlier writ petition
Page 93.
granted liberty to the petitioner to take steps to realize the dues in terms of the contract. Stop. The petitioner has not taken any steps
2008.
pursuant thereto. Stop. Paragraph.
I made
The payment sought for by the petitioner appears to be a contractual obligation between the parties. Stop. The writ court is not the competent forum to adjudicate the issue. Stop. Moreover, there has been enormous delay on the part of the petitioner in approaching the court for relief. Stop. In view of the above, the court is not inclined to
A liberty may be given, mother.
exercise jurisdiction in this matter. The writ petition fails and is hereby dismissed. No liberty.
I cannot approach because the city.
Don't approach because you are already time barred.
Because one of 93, I made a representation.
Yeah, you are already time barred. 93 and this is
In a writ petition, there is no
sir.
cause for condonation or delay.
116. Call 116.
116, I am appealing on behalf of the petitioner, my lord.
Yes.
My lord, kindly come to page number 76. There was an order passed by the subdivisional officer AGRA 1 directing the private respondent to removal of their encroached portions and gumtis. And this page number 76 was appealed against and an appeal was
77.
disposed of.
27 is the 10-4 application, my lord.
10 for application.
And subsequently, my lord, this appeal was disposed of. So, my lord, in that case, the
Upholding,
order passed on 76.
1 minute. Yes, yes.
upholding this order 76, the removal of those encroached portions.
You want implementation?
Implementation of this order 76, prayer B, my lord.
Yes. What steps are you taking to implement?
My lord, we will act in accordance to the order passed in page 76, my lord.
Another
Since
thing
the appeal
I
has been
want to
disposed
point
of.
out, my lord, there is one writ petition which is pending, which is preferred by respondent number 17 of this present writ application.
Which is the item number? Is it there in the
No,
list?
no, there is no stay even. In that
Stay is not there, but if the writ is pending, then both can be disposed of together, so the order can be complied with.
কি appeal গিয়েছিল?
No.
That respondent, my lord, in not all probability has not filed an application under 10-4.
Private respondent's writ number do you have?
Yes, yes, my lord. It is WPS 7808 of 2024.
7808 of 24.
একটা order copy দাও।
আচ্ছা আসুন তো। The petitioner prays for implementation of the order passed by the
subdivisional officer AGRA 1.
Subsequent event which has happened after filing of the writ application, my lord. It is not in the annexure.
Page 76, subdivisional
Not
mandate.
in the writ application, there was a prayer to dispose of the 10-4 application, my lord.
আচ্ছা prays for execution of the implementation of the order বললাম না কি বললাম? Passed by the subdivisional officer AGRA in eviction case number 534 of 2023. Stop. Next. Let the order dated 21st February 2024 be placed on record by way of a supplementary affidavit to be filed by the petitioner by 24th, with copy to be served upon all the appearing respondents. All the respondents, not appearing, all the respondents. Stop. Let the writ petition appear in the list on 11th of February 2025 along with WPA 7808/2024. Name of the parties ekটু দেখে নেবেন তো 7808 2024. Name, write the name of the parties. ইয়ের থেকে দেখে নেবেন, CIS থেকে দেখে নিতে পারবেন. Are you aware of the name of the parties?
Yes, I'm aware.
What is it?
Momin Ali Khan versus the state of West Bengal and others.
Momin Ali Khan versus state of West Bengal and others.
এটা তো এই পিটিশনটা জজ সাহেব জানতে চাইছেন আরেকটা যে মামলা আছে ওটা মনে
This is not Momin. This is Ajit Kumar Mondal. Yes. ঠিক আছে, Momin Ali Khan versus state of West Bengal and others. আচ্ছা.
Service.
Yes, service is taken on record. Let notice be served upon the advocate on record of the matter of Momin Ali Khan, intimating the next date of hearing, 11th of February. Service is taken on record. Yes. Hello, I'm for the.
I beg to appear on behalf of the petitioner.
117?
17.
My senior, Mr. Somnath Ganguly is already engaged in court number 11. In consecutive.
Who are you appearing for?
I am his junior.
Yes. And who is he appearing for?
My lord, there are two parties. State is a party, and my lord, there is one private respondent. My lord, private respondent service was attempted, refused. Now, my lord, the main, I won't say an allegation, but the names claims which my lord, we have claimed from is from the state government.
What is your prayer?
My lord, two things I should point out before your lordship takes out this petition. My lord, the order that has been impugned was passed way back in 2000. Now, my lord, my writ application is in the year 2024 challenging that order. Now, my lord, I have explained why, my lord, this delay was caused, as because, my lord, I was not aware of the, my lord, existence of this award. Now, my lord, what happened is, my lord, in 1917, there was an act in the British India.
Serve notice once more. Where is Mr. Ganguly? Somebody must be assisting him. Who is assisting him?
Priyambada Singh.
Where is she?
I don't know.
You do not know. You are making submission before the court.
No, he asked me to prepare before your lordship that time should be given.
Automatic. You ask and the court will give you time. The matter is pending for more than a year, nearly a year. An accommodation has been sought for on behalf of the learned advocate representing the state respondents. None represents the private respondent. Stop. Let further service be made upon the private respondent. Place the matter on 11th of February 2025. Learned advocate representing the respondents shall come ready with all necessary instruction on the adjourned date.
Grateful, ma'am.
In 118, my lord, Mr. Anindya Bush is appearing. He is on his legs in courtroom number 18. I'm seeking.
Where is the advocate on record?
Not the advocate on record, my lord.
Ashunto. The
short passover.
No passover. The
My lord, Mr. Omnaran Rai is appearing on behalf of the respondent bank, my lord.
All right. The matter was mentioned, citing urgency. Stop. On such request, the matter was placed under the caption upgraded motion. Stop. At the time of call, accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Let the matter appear in the combined monthly list of February 2025 under the heading motion. Record appearance of the bank or somebody. 119.
I appear on behalf of the petitioner, my lord. This writ petition was filed challenging the inaction of the respondents to revoke the order of suspension of the excise license of the petitioner. My lord, subsequent to the filing of the writ petition, a hearing was given and the proceedings have been completed. I have paid the fine, and now ultimately in the end of December, the shop has been the suspension has been revoked and the shop has been opened again.
Hey, please come.
This is the order, my lord. Kindly keep.
Learned advocate representing the petitioner submits upon instruction that the grievance of the petitioner has already been redressed. Stop.
This is the order.
An order passed by the additional district magistrate within bracket G and collector of excise, comma Paschim Mednipur, dated 7th June 2024.
7 June. No, my lord, last order.
And
that is, my lord.
25th
July, last order. My lord, second page. That
date order date लिखूं तो 25th of July 2024 has been placed before this court. Stop. Next. In view of the aforesaid submission, there is no requirement of proceeding with the writ petition any further. The writ petition stands disposed of.
my lord, a supplementary affidavit I have filed.
Very well. Supplementary affidavit filed in court today. We return with the records.
Grateful.
120.
My lord,
For the petitioner, your
my lord, I am
on the
appearing.
last occasion,
My lord, I am
your
holding the brief for the Union of India, my lord. Learned
lordship, last
TSG,
occasion,
Mr. Majumdar
our
is
time was
appearing in
sought
this
for.
matter. I have been requested to pray
Lordship,
for
on
a
the
day's
last
accommodation, my
occasion,
lord.
time was once sought for.
I'm not in this
already.
matter.
No, what this 120?
Yes, 120.
Well, again, it's a group for.
I have served upon the customs authorities, your lordship, and the Union of
Will the matter be taken up by this bench or by
Lordship,
matter taking up
this
group 4
lordship,
bench?
kindly looks into the facts of the matter, your lordship.
Why?
The
If it's a
lordship,
customs
kindly.
matter.
My lord, it's a
It is
custom
it's
matter.
a
I am
gold
appealing
which
for
is
custom.
seized, your lordship. It's
Lord,
a gold
Gold
which
seized by
is seized.
custom.
My lord, learned counsel, Mr. Majumdar is on his legs in another court, my lord. I have been requested to pray for a not today, my lord.
Already stated before
My
the
lord,
honorable court.
My lord, I am the main respondent.
Lordship,
Lord,
the
will
custom.
kindly seek.
Lordship,
Honored advocate representing the customs authority submits that this bench does not have determination to take up customs matter. Stop. Next.
Lordship,
In
I
view of
oppose
the
to the
above,
same.
let the matter be released from the list of this bench.
Lordship,
And
kindly hears the contents of the matters, your lordship.
bench having determination.
Lordship,
Go before some other bench. It is the same thing.
Lordship, Lordship, I cannot go before other bench, your lordship. It
Go
is
before
the
the Chief
gold which
Justice.
has been seized, your lordship, and
Go
the
before the
determination
Chief
lies
Justice.
before your lordship.
It's a smuggling case. It's a
121.
My lord.
Application for additional part in the application.
121.
121.
Alright.
Application for additional part is there. I have filed. Lord,
But I appear.
Society, Lord, TIH of the school, STIH of the school. Lord,
Who is for the petitioner?
Nobody is appearing.
Nobody is there.
No.
Dismissed. Record everybody's appearance.
Your lordship, item number 89, the
Please do
seniors
not
are here.
mention in the midst of the list, madam. I have already shown enough leniency. Do not do this.
Your lordship, the seniors are here, your lordship.
122, please call.
I beg to appear for the petitioner.
Yes.
I beg to appear for the petitioner. There is an application for addition of party. There is an application for addition of party. There some allegation has been made, but the division bench allowed the application. But this application contains certain allegations which I require to, my lord, object. I have to file an affidavit to that.
But I have filed an application for addition of party.
That has been allowed. Some contents are there which are required to be controverted.
May I just make submissions, my lord? My lord,
Who is the petitioner?
I am for the petitioner.
Oh, you are there. All
I am
right.
for the petitioner.
What happened, my lord, in June 2024, a tender was floated by PSI Hospital, Kolani. My lord, that I participated. There are other participants also in the same tender. My lord, they, my lord, challenged that tender process, my lord, on mainly twofold ground that it was floated through JAME.
Whatever.
Now the learned single judge passed an interim order restraining the hospital authority from proceedings, my lord, with the tender process. Now that was challenged by us in the appeal, and the state also challenged. Now the division bench thought that since it was interim order, my lord, kindly straightway come to page 60. Now tender is still stalled. Page 60, kindly see, Mala, there are two appeals. One was by us, another was by the state government.
Which page to be seen?
I'm sorry.
Which page to be seen?
60 of
60.
my application, Mala, can one.
Application.
Can one.
60,
sorry,
yes.
These are the now the appeal court did not incline to interfere. Kindly come to paragraph 5 onwards. Accordingly, the appeals and the correct application of this let the lead petition be listed before the concerned bench on 5th of November 2024. Next, by then the parties shall complete their pleadings and the appellant in MAT 1853 of 2 is granted leave to implead themselves in the writ petition. But I was the appellant in MAT 1853. And pursuant to this order, I filed this application within time. I don't know whether they have completed the pleadings because I don't have the copy of the writ petition also. Now, this is application has been made pursuant to this order of this Honorable Court, of the division bench. Now, this is the tender matter. Tender has been stalled.
I want to file an
The
affidavit to that.
existing is continuing. There are twofold grounds they have made out.
Who is the authority?
Lordship,
State is the authority.
State is the
ASI
authority. State is the authority.
Led by Mr. Kishore Datta, Advocate General, my lord, I was praying for
Lordship,
not.
19 July
Not
2024, Lordship.
It is the tender is stalled and y'all do not have any urgency in the matter. Who
Let
is
it-
continuing with the work in question?
I have to take instruction, your lordship. I have no instruction.
Mr. Dotto must have been assisted by somebody.
Yes, it's
Kopon
Kopon
Banerjee.
Banerjee and Shumita Shaw.
3 of them. Nobody present.
All are engaged in.
All let everybody remain engaged. Let the court proceed. What can be done? Isn't it?
Well, I'll be praying for an 1 week accommodation. So file an affidavit to that and come back to my lord.
Please come. The writ petition was heard by the court and an interim order passed on 19th July 2024. Stop. An appeal was carried from the said order by the applicant. What is your name?
My lord, Sonar Bangla.
Sonar Bangla, Lordship, Kerala.
By Messrs. Sonar Bangla Caterer.
And also state. State also filed.
And also state. Lordship, this is the order.
No, order is annexed.
Ache to their application edge.
And the superintendent, ESI Hospital, Kolani. Stop. The Honorable Division Bench passed judgment on 30th September 2024 by granting leave to the applicant to get them impleaded in the writ petition. Stop. Accordingly, the connected application being Can 1 of 2024 has been filed. Stop. Learned Senior Counsel representing the writ petitioner seeks time to file an affidavit to the said application for application seeking addition. No, not seeking. Application filed by the applicant. Stop. Next. An accommodation has been sought for on behalf of the learned Advocate General representing the state respondents. Stop. Paragraph. In view of the above, let affidavit to the application filed by the applicant be prepared and circulated by 24th of January. List the writ petition on 7th of February 2025.
Dateful.
Dateful.
না 7th of February 24 তারিখের মধ্যে ওদের অ্যাক্টিভিটি থাকে।
I appear on behalf of the petitioner. This matter relates to shifting of sites. Well, the
shifting of
an licensed excise site.
all right.
Well, the petitioner was carrying on business at his licensed site.
Where is your application?
Yes. Kindly comes, that is, an order has been passed.
Lordship, in this matter, Mr. Tonoy Chakraborty is appearing. I am not brief in this matter. Lordship, he has been immediately engaged in some other court. If your Lordship kindly takes up this matter tomorrow or.
Yes, page 33
Page
and 34.
33, your Lordship kindly comes. Page 32 is the impugned order, and page 33 is the relevant portion.
Yes.
Well, so far as the existing site is concerned, the rules say, may I first place at the rules and then I'll take that relevant portion.
Would you like to do the matter in the absence of the other side?
No, I think the presence is required because it's a legal point to be held by.
An accommodation has been sought for on behalf of the learned advocate representing the state respondents. List on 22nd, next Wednesday.
And since it concerns only a legal question, since it concerns only a legal question, so no affidavit is required.
Let them come and say.
Well,
next matter, is anybody there for the state? You are there?
No.
Very well. Same thing?
No, it's different. Well, over here, when a license is discontinued or stopped, the provision says that an excise license is renewable for every year. So there is a renewal fee for every year. And in addition to that, if a person does not renew the same, then there is a late fine which is levied as ₹100 per day. Well, over here, the excise license in question, that could not be operated due to the internal dispute of the licensees. Well, ultimately, that dispute was solved and everyone gave an affidavit. They are willing to run and continue the same. Now, so far as the quantum of fee was concerned, Rule 14.5 says that there will be 100 rupees per diem. But the authorities say, the respondents say, that since it concerns a renewal for over 1 year, what they are doing is they are charging at a cumulative rate. At the time of hearing, the commissioner says that there is some areas, so far as this rule is concerned, if it would have been within 1 year, then it could be applied. But since it is over 1 year, he has sought an opinion from the legal remembrancer. That was done 1 year ago. In last January. Still that opinion has not come, so far as most probably it has not come. I do not know. No further hearing has been held. I have not been communicated anything. The matter stays as it was in last January.
Lordship might fix a time period within which this appeal has to be disposed of, your Lordship.
Why don't you produce the opinion of the legal remembrancer over here?
Lordship, if there is any report, because legal remembrance, it's going to take some time, your Lordship.
1 year has already elapsed, your Lordship. Order of 30th January.
The prayer of the petitioner seeking renewal of the excise license is pending consideration at the end of the excise commissioner, as the said authority intends to obtain the opinion of the legal remembrancer. Stop. The order was passed by the excise commissioner on 30th of January 2024. Stop. The petitioner has not been made aware of any opinion forwarded by the legal remembrancer. Stop. No steps have been taken to dispose of the prayer of the petitioner. Stop. Paragraph. Learned advocate representing the state respondents is directed to file a report by the excise commissioner. Stop. List on
Lordship,
5th of February.
if I may pray, instead of giving me an opportunity to file a report, the Lordship kindly directs the appellate authority to dispose of the appeal within a time period, your Lordship.
Yes, time I will set. Let the report come. 5th of February.
5th of February.
Lordship,
may I, Lordship, item number 121, which your Lordship signed as liberty.
Gratefully.
Lord, item number 121, which your Lordship signed as liberty, may I mention I was present virtually, your Lordship, but I was not granted the access to the microphone or video, your Lordship.
My lady, I'm appearing in 125 for the petitioner, my lady. We have served the respondent. This is the affidavit of service, my lady.
They have served it online, I guess.
Please, my lady.
No, I have served by sheet.
We have also served by speed post, and they are here only, my lady. So, my lady, in this writ petition, we are seeking a writ in the form of a declaration that the impugned notification dated 13th of December 2011 is not applicable to the notice inviting tender dated 6th of January 2011, because the same was issued by way of the impugned notification. The respondent unilaterally changed the terms and conditions of the NIT after the bids were submitted and after the petitioner, which is me, was declared the L1. My lady, only after the execution of the works, handing over the project in 2020, December 28th, when we raised disputes with respect to escalated costs and overruns in July 2021, is after, in fact, once we invoked arbitration in May 2023, that is when we were notified of this impugned notification by way of which the arbitration clause stands omitted. Now, my lady, this is a unilateral change. No express communication of this change in the NIT When was the
the contract issued in your favor?
My lady, the contract was issued. The letter of award.
2011.
The letter of award is dated 3rd of February 2012, my lady.
12.
Please, my lady.
All right. And the work was to be concluded within which period?
Within 4 years, my lady.
4 years.
Extended
so within
time.
16, extended time?
My lady, the time extensions were given because there was issues with respect to
whatever. Now, what was the last date of conclusion?
Completion? Yes, my lady, that was 30th of December 2020, and project was successfully completed and handed over on 28th of December 2020, my lady.
2020.
Please, my lady.
Then issues arose with regard to the payment.
No, my lady. Because of the delayed project timelines, there were cost overruns and idling charges, etc., for which the petitioner kept notifying the superintendent, respondent number 2. And finally, in July 2021, we sent a communication, which is, my lady, which is annexed as Annexure P11 of the writ petition.
Which page do I get that?
My lady, it is in volume 3, page 136.
All right. Yes.
My lady, this is the first written communication with respect to the escalated costs. This was not responded to. In fact, even before this, my lady, the government, my lady, I'm so sorry, my lady, just one second. My lady will have in volume 3 itself at page 130, there was an advertisement published by the government of respondent number 1 seeking intimation with respect to stressed projects. And here also, my lady, the petitioner had replied, and on page 131, Annexure P10, by letter dated 5th of August 2020, the petitioner had intimated the government that this is a stressed project and there are cost overruns and an amount of 46 crores at that point in time, my lady. Now it will be enhanced because of interest, etc. But at that point in time, the overruns were amounting to 46 crores, my lady. This intimation was also sent. Then thereafter, my lady, on 1st of July 2021, which is after handing over and completion of the project, my lady, to respondent number 1, respondent number 2, a communication was sent with respect to cost overruns, my lady. No response is received. Thereafter, on multiple occasions, the petitioner kept pursuing with the respondent number 1, no response.
These are all regarding the payment of your bills,
damages. Please,
otherwise, yes, I understand,
Please,
not in accordance with the contract, but because of the delay in conclusion of the project, there has been enhancement of the charges and everything. So you want your money claim to be paid.
Please, my lady.
Right?
Mala, their prayer is otherwise, your lordship.
Prayer
Their
is
prayer
otherwise?
is, yes, your lordship. If your lordship may kindly come to the prayers, your lordship will see, my lord, they have challenged the second notification whereby, my lord, they are claiming that unilaterally the arbitration clause has been deleted. My lord, this is their prayer, and my lord, the prayer too is, my lord, for the direction in the nature of mandamus directing the respondent number 2 to cooperate with the sole arbitrator. My lord, when the unilaterally, my lord, as alleged by them, when, my lord, the arbitration proceeding, there was no clause for invoking arbitration, my lord, that was published back in the year of 2011. My lord, they have completed the work in the year of 2023, your lordship.
23, not in 20 also.
No, 2020. 2020. I stand corrected. 2020. My lord, meanwhile, they have not challenged it, and this was by way of a gazetted notification, your lordship. They have not challenged so. My lord, today, if
Show
they are
the notification once.
lordship, it is annexure P3, your lordship.
Page.
110.
My lady, it's 110.
110.
110.
Please, my lady.
Notification. And this is a gazette notification.
Yes, your
Yes, my
lordship.
lady. Where is the matter of dispensing with the resolution? Matter of dispensing through arbitration of disputes and contract. That there shall henceforth be no provision for arbitration for resolution of the disputes that may arise out of the contracts to be entered into by this department for the purpose of when was the contract entered into?
My lady, it is 3rd of February 2012 is when the letter of acceptance was issued. My lady, I am not denying. I have not concealed any facts, my lady. But the question here is that after submission of the final bid, after declaration of petitioner as L1, there was a delay at their end, at the respondent number 2's end, and it is admitted, my lady. I will show the page. My lady,
No, but then prior to entering the contract, this notification was in place, isn't
Yes,
it?
your lordship.
My lady, let me show page number 111. For the first time, express communication of this notification was made to the petitioner only on 12th of July 2023 by respondent number 2, my lady, which is, I'll show, my lady, it is annexure P14 at page 142 of volume 3, my lady.
Thing is, when any document is put up in a gazette, had it not been gazetted, you could have submitted that there was an order from the end of the respondent which was kept in their office book only, and it was not published, and you did not have notice of it. But once it is put up in the gazette, it means that it has come to the notice of all the respective parties. And now can you take
My lady, I'm relying on a judgment of the Honorable High Court of Orissa. My lady, if I may pass over this compilation of judgments. This is index item number 5, my lady, which says specifically that the publication should be communicated in the same manner as the notice inviting tender, my lady. It was never done by respondent number 2. Respondent number 2 issued the notice inviting tender. Respondent number 2 is the party with whom I am communicating. I am entering into a contract virtually, my lady, with respondent number 2. Respondent number 1 announces a gazette notification. It's not a denied fact that this is a gazetted notification, my lady, but I have also placed judgments on record of the Supreme Court, Honorable Supreme Court, which say that after submission of the bid, after notice inviting tender, any change in the terms and conditions could not be made unilaterally, my lady. It has to be expressly communicated in the same manner as the notice inviting tender, my lady. That is this judgment of Orissa High Court is index item number 5 at page 37. It starts. Just one second. And I'm only asking for arbitration, my lady. I'm not denying them anything. I'm just asking for a determination in a proper manner. I will justify all my prayers before this court, my lady. May issue notice. Give
but
me
then why arbitration? Why not in a suit proceeding? Suppose arbitration is not there. Yes, relief in a suit is always available.
My lady, I bow down,
Lordship,
my lady.
they have
but
preferred
today,
a can
my lady, it is
application.
my
1
petition,
minute.
if I may submit. My lady, I bow down to the court, my lady. And that was my first advice to my clients as well, my lady. And however, my clients insists that arbitration is less time consuming. And we want a faster determination because this is an long overdue, and they've also suffered losses during COVID in this project itself, my lady. So they are only requesting the party to honor the terms and conditions of the NIT, my lady. Then nothing else, my lady. So it's not a wrong prayer, my lady. We are not challenging the notification. We are not asking for the notification.
No, your submission is whether this will be applicable on you or not. This is the only issue to be decided.
Declaration that we are seeking.
Nothing more than this.
Nothing more than this, my lady.
My lord, they have preferred a CAN application, my lord, which is registered at CAN 1. My lord,
Yes, my
in that, my lord, they are stating that they want to file a commercial suit, my lord, and for that they are seeking
We are not saying that, my lady. That is a wrong submission.
That must be an alternative submission.
My lady,
If the writ petition fails, then commercial
the
suit.
application is only seeking stay on my limitation period because it is expiring on 28th of February, my lady, and that is my anxiety. That if
I think that the limitation period
already
is already
over. It is already over.
My lady, because of the COVID, the Supreme Court had suspended limitation. So
Well,
my time
that
has only begun to run from 1st of March 2022 and 3 years expire on 28th of February 2020.
That is your way of interpreting it.
Please, my
Nevertheless, then this is to be heard.
Lordship.
I'm so grateful, my lady.
You will be representing both the respondents?
I'll be representing.
Very well.
My lady,
please.
I'm being led by Mr. Jishnu Shaha in this matter, and he unfortunately had his mother passed away, my lady, 2 days ago. So my lady may fix this matter for hearing anytime at the court's disposal, however, at the earliest after 10-12 days, my lady. Right? After 23rd of January, my lady.
Achha, the issue to be decided in the instant writ petition is whether the Gazette notification dated 13th December 2011. The notification number number 558/SPW dated 13th December 2011 can be made applicable in case of the petitioner. Step next. The parties are directed to come ready for arguments. List on 31st of January.
I'm so grateful.
Lordship, if it could be, my lord, the first week of February, or Lordship.
No, she has
one day,
some urgency in the matter.
First or second, your Lordship.
No.
First,
Yeah. Affidavit of charges is taken on record. Right.
Lordship.
315 matter, 415 matter fixed.
31st.
Fixed. 415 call.
31st.
Lordship, if I'm audible with your liberty, may I mention item number 121, your Lordship?
This item number 121, my lord, I was appearing all along, my lord, on online. My lord, I was not allowed to enter, my lord. I raised my hand and all the my lord, it was dismissed for default and I was running on my way. I was on my legs, my lord. Item number 121, my lord.
1 minute. We are in the midst of a list. Item number 8 of the daily list.
I'm obliged, your Lordship.
I'm for the one of the respondents, my lord.
Yes, Mr. Nondi is there online. Huh?
My lord,
Yes.
I mean, it's not 15, my lord. It's not 13.
All right. Yes, Mr. Nondi.
My lord.
Yes.
Yes, my lord. Am I audible?
Yes, I can hear you, Mr. Nondi.
Yes, my lord. My lord, this is the first item, item number 8, 5008. My lord, kindly see the supplementary affidavit, page number 13. My lord, kindly see the page number 13.
Supplementary affidavit kothay?
Yes, my lord, supplementary affidavit.
Yes, page number 13.
13, the forensic.
Yes.
Yes, my lord. The para number 1, marriage registration certificate dated 13 August 2009 is once it contains question signatures reading Taposi Ghosh, Kolyan Krishna Nandi and Nitanandi Mani in English on the offers initially and marked by me as Q, X and D respectively. And the second item, Form 4, application for registration of a marriage under Section 15 of the Special Marriage Act 1954 in one sheet contains question signature reading Kollan Krishna Nandi and Nita Nandi Bani on the reverse initiated and marked by me as X1 and D1 respectively. And item number 3 is inventory of immovable property in the one sheet contains a question signature reading Nita Nandi in English on the obverse initiated and marked by me as D2. And item number 4, money order acknowledgement for rupees 5,000
So
contains
what you
an
want to show
admitted.
from here? What you want to show from here?
Yes, my lord, I want to show the respondent number 21, 22, and 23 that Kollan Krishna Nandi, whether it is existed or not, and the fraudulent the marriage registration certificate, there are various fourth certificate. That is why I am reading this forensic. The previous 6 day was, I have tried to read this forensic, but that was not happened. That is why I am trying to read that forensic. My lord, on which papers the forensic has made, that was from the page number 19, 20, 21, 22, 23, and 24. My lord, the original signature marks a T, page number 19. That is of Kollan Krishna Nandi. That is the original signature, marked as T. Now, my lord, the marriage certificate book, that is page number 20. Kindly see the bottom portion, the certified to the true copy, the signature of Kollan Krishna Nandi marked as X, and signature of Nita Nandimani marked as D. Now, page number 21, that was tested. The signature of Kollan Krishna Nandi, that was X. So, X and X2, there is, and there is also Nita Nandi's signature on a questionable document of MAT execution 5 of 2015. That signature is Nita Nandi marked as D2. And the money order of Nita Nandi, that is marked as A, page number 23. And the Tapusi Ghosh, who is the marriage register, his acknowledgement AD card signature is Tapusi Ghosh marked as S, page number 24. Now please come as the analysis of the forensic. Malat, page number 14.
Why will the writ court go into all these details?
Yes, my lord, I am trying during 2011 at the learned court below. My divorce case was filed at 2010 and never I have able to exhibit that forensic there. My divorce case was dismissed on 2017. Various execution case was there, and these execution cases also did not opine their opinion regarding this forensic, and each and execution was disposed that my payment was already been made. Now one execution case is also running. There is no single default of payment, but still now my salary was seized during 4 years. Till date, I have not obtaining any salary. That is why the fraudulent exercise of the real Kollan Krishna Nandi and the fraudulent Kollan Krishna Nandi and real Nita Nandimani and fraudulent Nita Nandimani never exercised and opened before the learned court of trial court, not in the JM court, not in the ADJ court. They have challenged before this
All
writ
these
court.
things, Mr. Nondi, all these things have to be looked into either in the revisional jurisdiction or in the trial stage. The writ court sitting here cannot look into all these things at all.
Yes, yes, that is absolutely, my lord. But the respondent, on behalf of the respondent wife, they have challenged that respondent number 21 and 22 and 23 are the same person. And that is why it's very much ridiculous and mockery with the judiciary system. That is why I am trying that this is not happened by me. My lord, the activities of these types of advocates against whom, why, my lord, you have asked in the earlier occasion that why I'm against the learned advocates. My lord, in the 3 James Court criminal case, contempt case, C676 and C1315 and C1316 of 2024.
I once again repeat, all these things cannot be adjudicated in the writ court. Where is Mr. Chatterjee?
My lord, Mr. Chatterjee is just, he has said that kindly informed him, but as I am online, my lord, I am gone at the 8th, 9th and 10th and 13th and 14th, but that was not taken. That is why I am virtually come. My lord, kindly fixed at any time when learned amicus curiae is also present, and by presence of physically, it will be very much easier. My lord, my kindly pray for fixing any date when amicus curiae and I will present physically, and that will be very much easier to all of them.
No, you
Kindly
can
fix
appear
any.
online. There is no difficulty, but let the amicus come.
That is why learned amicus curiae
Because
is not.
it may be that the matter is there in the list and it is not taken up, and then you will come all the way by not attending your school, remaining absent from school. Let
Yes,
it not
my lord. That is why
that
I am
manner.
not absent of school and I am not taking
You
money
remain
during.
present online, no difficulty, but let the amicus be here. Please come. Heard the petitioner appearing in person virtually. Stop. The amicus curiae is not present today. Stop. Paragraph. Let the matter appear in the list. Next Wednesday, I am posting 22nd.
Yes, my lord. Grateful.
The petitioner shall intimate the amicus the adjourned date.
Yes, grateful, my lord.
Yes, now.
My lord.
Wait.
My name is kindly recorded 15.
121.
1 minute, the advocate here is mentioned.
Your Lordship, all the respondents are here, Your Lordship.
Item
Taken the instructions from senior Mr. Carr, Your Lordship. He's stuck before courtroom number 2, but her clerk is here. He said that he has no objection if the matter is kept tomorrow, Your Lordship.
But instead of tomorrow, can it be next week?
Done. Just now she has mentioned immediately thereafter. Now, if you say formal notices to be issued, the order will be signed in the meantime.
Mr. Kaur has given instructions. His clerk is.
She is specifically submitting that she has intimated Mr. Kaur and making submission.
But I had missed the matter. As I told your lordship, I had some medical appointment.
Whatever. 121.
89, Your Lordship.
Yes, sir.
Of the monthly list.
89.
89
of the monthly list, madam.
89 of the monthly list. Messrs. Green Tech Environ.
Yes, Your Lordship. 24833, Your Lordship.
This is restored.
But can it appear anytime next week, my lord? I'd like to come physically. I'm a bit under the weather.
89, it's there in the combined list, and the adjourn motion bundle is over already. Ajay, please come. Legal intact order has been sought for by the learned counsel representing the petitioners. Stop. List on 15th, 29th.
Grateful, Your Lordship.
29th of January.
Grateful, Your Lordship.
Grateful.
Somebody mentioned some other matter.
121.
Yes, Your Lordship. Yes, Your Lordship. Item number 121, Your Lordship. I had been appearing online all along, Your Lordship. One CAN application had been filed by the private respondents without serving as the copy, Your Lordship. Kindly fix any date in the coming week, Your Lordship.
121.
My lord.
There is no CAN on the list.
My lord, one CAN has been filed by one intervener, my lord. It is not the respondent. My senior stands corrected, my lord. One intervener, my lord, has filed one CAN 1 of 2025 that has been served.
What has happened? Has it been dismissed?
My lord, it has just been dismissed, my lord.
So let it be restored first and then make submission.
My lord.
Was your other side there? 121 দেখুন other side ছিল? অনেকেই ছিল?
Yes, Your Lordship. Lordship, if Your Lordship permits me, I can mention tomorrow after issuing a notice, Your Lordship.
In the meantime, the order will be signed and you have to come up with an application. I'm not going to keep the matter pending. Who was there?
Lordship.
Have you
Lordship,
brought the other side?
No, my lord.
Why not?
Other side is not here, my lord. Other side.
Other side was present at the time of call.
My lord, I believe, my lord, the intervener might be present, my lord.
Whoever. Somebody was there.
Yes, that is the intervener.
It's very difficult. In the absence of your other side, it cannot be
My
restored.
lord, kindly restore it, my lord. I'll serve notice.
Sorry, sir.
I'll serve notice. My lord,
Sorry,
I was
sir.
appearing all along.
You did not appear. at the time of call.
My
The
lord,
other side
online
was there. And when it has been dismissed in your absence, it will be
Your pa-
restored in their absence. Can it be done?
No, my lord, I
Then
beg your pardon, my lord, but I was appearing all along, my lord. I even raised my hand, my lord. I was not allowed, my lord.
do one thing.
Monthly list.
121টাকে কালকে টু বি মেনশন রাখুন তো।
I'm obliged, Your Lordship.
টু বি মেনশন কালকে রাখবেন। হ্যাঁ। Anybody else mentioning anything?
I'm deeply obliged, my lord.
I'm obliged, Your Lord.